maybe take a month or two to get something.
It comes from Jake's office. So how it
Commonwealth versus Jesse Pitman. Yes.
Okay.
Okay, y'all gonna have to quit the talking right over there. You're keying the microphone. Okay. Commonwealth versus Alfred Silva, 23 CR 0012 and 23 CR 0048. Are you Alfred Silva?
Yes, Your Honor.
Born in 1962.
Yes, sir.
Last produced Social Security number 3706.
Yes, sir.
You're here today for the purpose of sentencing. If you have an opportunity to pre-sentence investigation for benefits from the probation control,
Yes, sir.
is this substantially correct?
Yes, sir.
Counselors,
No, Your Honor, just for the record, I will know, given that the court was moved up a few days, I think the day's credit might be off on the PSI, given I believe Mr. Silva's, but
well, that's probation for all the
certainly, Your Honor. But aside from that, no, Your Honor.
plead guilty to indictment number 23-012, charging all transactions in the matter secondary to the defendant shall receive a sentence of 5 years. Laura, plead guilty on information indictment number. And what is information indictment number? What it is? 23 CR 0048 for the charge of sexual abuse secondary. It should receive a sentence of 5 years. 23 CR 0012 12 months shall be concurred. For a total of 5 years, so 209 days in jail, without probated for 5 years. Supervising offender shall have no contact with the victim. The offender shall receive credit for time served. They shall have annual employment will be 30 hours a week minimum. Public service. All evidence is destroyed.
Yes, Your Honor.
Thank you very much. The court costs is court costs are $30 a month, 30 days after you release, maybe $30.
Yes, sir.
Okay.
And Judge, just as a point of order really quick, Mr. Silva may be going straight from jail to rehabilitation. So if that's the case, we would just ask if the court would relax those.
That's true. If he does that, if he goes into a long-term rehabilitation, contact me, I'm gonna wait for the cost of this.
Judge, I'm just awaiting the vet later, so that's the plan. And I'll,
If he
yes,
does, give us something in motion, and I'll wait for the cost.
thank you, Judge.
Thank you, Your Honor.
Okay, Commonwealth versus Jesse Pitman. Okay, this is Commonwealth versus Jesse Pitman. This is 18 CR 0074. Born in 1986, last one is social number 5676.
Yes, sir.
This is a motion to vacate. It looks like it's done by the petitioner himself. Are you joining in this motion?
Your Honor, I have not reviewed the motion, and I will say on the record, I've contacted DPA, even up to Frankfurt, to see if this is within the scope of representation. I've yet to receive an answer.
What's the comment?
Your Honor, I've looked at this, both cases, and I would go with old axiom, two wrongs don't make a right. Got two separate cases here. This 18 case that Mr. Pitman's filed a motion to vacate involves different victims with a legitimate judgment. Now, I think that case needs to stand. I don't doubt that Mr. Pitman may have been mistreated by the parole board, but his remedy is with the parole board, where he needs to file a motion for reconsideration, whether he needs to do a writ, federal writ of habeas corpus, there's other remedies. But this 18 case shouldn't be filed.
I can't really read this, get it fulfilled. Like it says, defendant has to vacate due to a falsified police statement and record dismissed indictment.
What happened, Your Honor, let the clarify. Mr. Pitman was recently indicted on a domestic violence assault case, which the Commonwealth dismissed after reviewing that case. Now, the parole board
That
revoked
was
his
23 CR 0037, and they revoked it based upon that.
based upon the allegation, prior to any judgment or anything. They revoked his parole based on that allegation on the domestic violence case, which I think, based on my experience, is fraught with her, but that's what they chose to do. So I think his relief should be with the parole board. And I understand where you're coming from, and I don't want out of jail, but it's not. That 18 case was involving a stolen truck with Philip Gross, another victim.
I'll explain when you're done the reason why I
We
can't.
can't relitigate that. The parole board is where any relief needs to come from. And I think DPA should be finding something to represent the parole board.
After 21 days from the parole hearing, I don't have any grounds for appeal whatsoever. I've already tried to go that venue. That was the last avenue I have, was to come to you with this. I tried to go to the parole board to start with, and it's past anything past 21 days is.
I disagree with you that you don't have any other avenues. There's other remedies, federal writs, there's other things you can do. There's not. It's not.
Well, what was the circumstance on dismissing this charge?
Well, I felt like they're looking at evidence.
Tell me what the circumstances were.
Evidently, Mr. Pitman was in a relationship with this lady. He was allegedly had held her against her will, and that there was an altercation at the time. I had a terrible time tracking the lady down to rehab. When I finally talked to her, she just wanted to get on with her life. Yes, and I just don't. I believe there was defenses to the matter. I don't want to go into great detail on the record.
Your Honor, Mr. Pitman and his father went to get the alleged victim in that case. She was the one that actually contacted Mr. Pitman to come get her. The circumstances, she was court ordered into rehabilitation, absconded from that rehabilitation, and was granted permission to go to another rehabilitation
Well,
center.
I'm not gonna rule it, I'm not gonna rule against you today, I'm gonna take it under advisement. It's kind of a thing of new impression, yeah, I've never really seen anything like that. There could be, there could be some reason to throw more vote based upon other actions that were involved in that might not be criminal in nature. Was there any alcohol used, or was there?
I'm familiar with what the parole board did and why.
Well, I mean, underlying events that you investigated, what I'm talking about. I'm gonna give you until, I'm gonna take it under advisement. We're next here on January the 11th.
Yes, Your Honor.
Sometime before you investigate whether this has any other avenue of relief. Whether a motion, making an argument on motion to vacate is appropriate. He makes his motion, but he doesn't give any authority for the court to be able to do it. Maybe you could help him do that if
Absolutely.
If you need an order appointing you to represent him in this case, I will sign that if your superiors request that, okay?
And please do, Your Honor, and
You submit an order doing that, and we'll take a look at this, thing, Mr. Pitman.
Thank you, sir.
Thank you.
thank you, Judge.
Commonwealth versus Daniel Boston. Commonwealth versus Daniel Boston, 23 CR 004. Daniel Boston, 1982. Last four digits of your social security number 908. Here for pre-trial conference when you have.
There's a,
Would you come around on this side of Mr. Boston? You get behind the mic.
yes, we have a, this is a, there's a co-defendant in this matter, and it's set for trial, earlier this, I guess, just a few
Move over to the side.
days ago.
What's going on?
Well, I'm waiting to dispose of Mr. Boston's case after Mr. Key's case is disposed of. If he enters a plea today, it'll be disposed of.
I'm probably not going to accept it.
Well, we need to get a trial date and move on. Okay.
Let's continue, him out to, is it all right, the Commonwealth to continue him out to, let's say, March the 7th?
That's fine now.
Okay, he'll next be here in court on March the 7th. Rick Carver.
Judge, the Commonwealth and Mr. Cross's office had come to an agreement to continue. Oh, I'm sorry. The Commonwealth and I had come to an agreement to continue Mr. Carver's case.
Where is Mr. Carver?
I know we prepared an agreed order to continue the case, and we sent it to Mr. Krause's office. That's the last one I know that. But I informed Mr. Krause last week that I'm meeting with Bluegrass tomorrow morning at 10 o'clock. I'm going out to the facility so I can hold the case with them. And that was the first time I had where they would have their accountant.
You tell your client who's on the docket, with or without an agreement, he's expected to be here.
Yes, Your Honor.
One of the things we do when people come back is we observe their demeanor and how their deportment is, whether they have an influence and things, so he needs to be here. Mr. Cross or nobody else can tell him not to be here when he's on the docket. Do you understand that?
Yes, Your Honor.
Okay, he needs to be back here. Is Commonwealth gonna be ready by January the 11th?
Yes, I'll be ready next week.
Thank you.
Virginia Captain. Commonwealth versus Virginia Captain, 23 CR 0045.
Yes, Your Honor.
You want that name and time?
Yes.
Last four digits of social security number 58 on that.
Mhm.
Your day for the purpose of sentencing. If you had an opportunity to review the pre-sentence investigation for him, probation parole,
Yes.
did you do so with your attorney?
Yes.
Counselor, is there any reason this lady should not be sentenced today?
No, Your Honor.
On plea of guilty to theft of all Texas disposition of firearms, she will receive a sentence of 5 years, probation for 5 years. She shall be referred to social service clinician and follow recommendation. Then she shall pay restitution in the amount of $90 plus a 5% clerk's fee. Monthly payment of $100 plus 5% fee at the rate of $105 payable at the clerk's office first payment. Was due to 30 days after the enforcement. Is that payment been made?
Not yet.
When was the plea done? It's not late. It's not late. Oops, y'all sign this, thing, you read that.
Yes, Your Honor.
So you haven't paid that.
No, I'll make a payment today though.
Do what?
I'll make a payment today.
You're supposed to make it in 30 days.
I didn't know that.
But I think she just had planned on making her payment the day of sentencing. I think there was more than 30 days between our last rule day and today's.
It was, and it says it's supposed to be 30 days. You gonna pay it today?
I pay $100 today.
Second. Okay. You need to, do the probation for
Grand jury. Betty.
You solemnly swear or affirm that you conduct your duties as a member of the grand jury and that certain scale matter of
Yes.
Mr. Posey, are you going to take? No, we'll just thank you, sir. Felicia Daly. Says there's an active warrant out for Felicia Daly. So Jamie Harrell, sentencing. Morning, Mr. Harrell. Commonwealth versus Jim Harrell, CR 041, Margin Harrell. For 1977, last for reasons of Social Security, 25. An opportunity to present investigation for an application for this is substantially correct. Counselor, any reason this gentleman should have been sentenced?
No, Your Honor.
On plea of guilty possession of controlled substance first degree, shall receive 3 years probation, 5 years supervised, finish this in period of time served. It should be moved to employer to remember 30 hours going for employment until total service until the employment is obtained. All evidence shall be destroyed. What costs this? 155.
Yes.
Should pay the court costs $155. You pay $30 a month.
Yes, sir.
Okay, make your first payment. 30 days to pay. Okay. Then you need your probation parole. Cody Key. Commonwealth versus Cody Key. Cody Key. 23 CR 0005, 23 CR 0014. Born in 1984.
Yes.
Your last 4 digits, social security number 21. Yes, sir. Does Commonwealth come around? Y'all step to the side.
Well, I guess we're getting a trial date.
Well, I mean, I don't know what the plea agreements say.
Well, but evidently, we don't have a plea agreement according to his attorney.
Yes, Judge, negotiations have broken down in regard to a plea agreement, so we're all of the
Well, you
opinion.
alluded earlier that there was a plea agreement. but
Old Springs, Carver, we're gonna try.
It's a one-day trial.
Should be. Well, I don't know. It depends on whether I introduce the 404B. Could go into 2 days. Better send it to.
What about January 8th?
Well, maybe Mr. Crosby.
Yes, Judge.
Only issue I've got to get the subpoena served, Your Honor, and I know I've got one witness, might be difficult, I'll see.
January 8th and 9th.
Thank you, Judge.
Actually, Custer. Commonwealth versus Ashley Custer, 3 hours, 004.
Yes.
Ashley Custer.
Yes.
Last 4 digits of your
457.
This is 23 CR 0049, for the purpose of arraignment. Grand jury of Clinton County returning indictment charged with assault in the fourth degree, criminal abuse in the 2nd degree. Do you understand those charges?
Yes.
Counsel, you acknowledge receiving indictment, then you with formal arraignment, you're pleading not guilty, reserving all violations.
Yes, Your Honor.
And we'll sign a reciprocal discovery order, Mr. McCasker, here, the Commonwealth has to give you the evidence that they have. When is your negotiation day?
January the 5th at 9 a.m.
January the 5th. The next court day is January 11th, and both of those are conditions of the bond, okay?
Judge, just as a point of order, I believe the caption in the order I have says Monroe County. I didn't know if yours did as well as wrote in.
Yes, you're talking about the indictment.
On the reciprocal discovery order. Okay. Just wanted to make sure mine doesn't. So,
Darryl Murphy.
you need those dates?
Yes.
Commonwealth versus Darryl Murphy, 19 CR 009, 18 CR 0015. Darryl Murphy. Yes, sir. Born in 1974. Yes, sir. Last 4 years of social security number 4535. Yes. Probation, revocation, and all of these cases wasn't.
Your Honor, he was
To the right, that's your turn on the side.
He was here last month on probation revocation. He hadn't turned in his prescriptions for his medication. I've been informed of probation parole that he's turned in his prescription for oxycodone, so he's in fine shape at this point in time.
You guilty? What was the problem with Oxycontin? Well, what's the Commonwealth know that it's problematic? Somebody did a pill count on him?
No, he was testing positive for oxycodone, and he wasn't furnished any prescriptions showing that he could take it.
He sustained a, was a
Well,
arm
I
injury.
didn't know, I wish I was in there. You got a prescription, that's a decision. But I want pill count. Okay.
Yes, Your Honor.
But we'll make arrangements. Jeffrey Gray. Commonwealth versus Jeffrey Reagan. Jeffrey Reagan.
Yes, sir.
Born in 1960.
Yes, sir.
That's what his social security number 7413.
Yes, sir.
Here on the 23, CR 035 probation. What's the comment? You move over this way, sir?
Your Honor, this is another case where we were here approximately a month ago on a motion to revoke. Mr. Reagan has a DUI, fourth, 5-year sentence. After serving quite a bit of time, he was probated. The last time he here, his problem was he had benzos and marijuana in his urine without a prescription. And the court lectured him, told him not to be back without anything, any system without a prescription. And then he showed up on November the 27th, 23 with Xanax in his system with no prescription.
And Judge, I received a copy of that prescription, or excuse me, of that citation. Judge, I'm not a chemist, but it's my understanding that some of these drugs and substances take longer to filter through the system.
Do you have a testimony to support your, like, fact that you're not a pharmacist or a chemist?
Judge, I do not have.
Swearing you don't testify.
I don't know that that's kind of lay opinion, but
That makes- What do you want to do with this?
I don't know, give him a chance, and, if you read the report, he's got about, we could go through this, Mr. Morrow has had to keep up with his medication, because he has so many medications he takes, and he's been taking so many medications over time, and he hadn't had prescriptions for. I don't know, how many violations is this?
This is the 10th violation report since I took the case load in 2022.
So what can you do?
Judge, I believe we've got a case of a man that needs possibly some treatment for this.
He's getting more treatment than he is right now. It's probably self-medicated. What would you suggest? Yeah, I'm gonna tell you what, Mr. Reagan. I'm not gonna let you continue to go this probation program. You give me your opportunity. Let's time you serve that.
I don't know his jail credit right off.
He had probably 7 or 8 months, and before he ever entered the plea, he'd probably be paroled up in 2 or 3 months.
I think that's the best thing to do.
Your Honor, if you give me one more chance, I promise
I've
you.
already given you all those chances, okay? It's a problem. This we can do is maybe if you're incarcerated for a while, then parole and supervision and parole is not quite as bad. What would you, do you have any suggestions on anything short of the imprisonment?
Mr. Reagan has completed the IOP program. While in the IOP program, they extended the amount of positives for Mr. Reagan. We got him through it, but I don't know at what cost.
Drug you through it.
His thing is just having extra of what he's got. He's got a script for benzos, but he's also got 2 other kinds in there with him. So it's not just over medicated, it's medicated with additional benzos is the thing.
Kind of dangerous.
Yeah, I was gonna say, we'd probably be reading that in the paper.
Now, sir, you give me one more.
The portion of paper we read that got you in it. Into the obituaries. That's what we'll read about you, I'm saying that seriously. You know, one of the things that I really worry about is somebody like you that can't get off and won't comply, get in the vehicle, run over a school bus, or find you dead at home from an overdose, and then members of your family write me a letter and ask why we didn't do anything about it. You see the situation I'm in?
Yes, Your Honor,
Okay, well, I'm gonna jail you until, take it under advisement, I'm gonna jail her. And, I want, by January the 11th, I want you to get some sort of, idea for Mr. Reagan as far as a long-term treatment or something like that we can put in, and the time between now and then will be sanction time for the violation. I'm not gonna revoke him right off, because I don't know where they can put him. He looks like to be, in poor health. Got something wrong with his wrist.
I've got 3 appointments between now and the first of next month, or
Well, they'll get you there. Okay. Thank you very much. He's in custody of the jail.
Just for clarification, you want our clinician to do the referral or DPA?
Or y'all. And you, so.
Thank you, Your Honor.
Kelvin Riviera.
Your Honor.
Yeah, Kelvin Riviera. Here, maybe Riviera.
Good morning, Your Honor. Do you need an interpreter for this case?
We will need to move this screen around a little bit here. Okay, the interpreter, will you raise your right hand, please? You swear to affirm that you are qualified to interpret matters in the courts of the Commonwealth of Kentucky and recognize this interpreter.
I do.
This is Commonwealth of Kentucky versus Kelvin Rivera.
Este es el caso de la Mancomunidad Kentucky contra Kelvin Rivera.
Mr. Rivera, were you born in 1989?
Señor Rivera, ¿usted nació en 1989? Yes.
Your social, last 4 digits of your social security number, 6235.
Your Honor, the interpreter cannot hear. Could Your Honor repeat, please?
Okay, let me speak up a little bit. Is that a little
Thank
bit better?
Yes, sir. Thank you.
Okay. Are the last 4 digits of your social security number 6235?
Las últimas 4 cifras de su número de seguro social son 6235. Yes.
You're here today on a pre-trial conference in 23 CR 0047.
Usted está aquí presente para una audiencia previa al juicio, para una conferencia en el caso 23 CR 0047.
You want to move over to Commonwealth, want to come up? Do y'all have an agreement in this case, or are there negotiations going on?
¿Ustedes tienen con la fiscalía algún acuerdo o tienen negociaciones en proceso?
Judge, we're close. We're, I guess, squabbling over some home incarceration days at this point. We're close.
Señoría, estamos aproximándonos a ello. Estamos repasando pues fechas de encarcelación y tal, pero casi llegamos.
Well, let's just get a trial date.
Boys, come up here. I don't know. What are the charges that you're negotiating on?
Pero necesitamos una fecha para el juicio, si de acaso. Por favor, acérquese. ¿Cuáles son los términos de qué es lo que se están negociando ustedes?
Fleeing and evading first degree, no insurance, and a raft of, I don't know how he was driving legally in any way other than that. So we got-
darse a la fuga, no tener licencia, no tener la aseguranza y toda una ristra de cosas, la verdad.
5 years, probated for 5 years, served an additional 45 days home incarceration with a $500 fine on the no insurance.
Your
So,
Honor, the interpreter would
I'm ready to go to
request that.
trial.
Your Honor, the interpreter would request that counsel speak into the microphone and repeat.
I'm withdrawing the offer at this time, Your Honor, and requesting a trial date. I'll make it simple.
For the record, Your Honor, the interpreter has not been able to hear counsel except the last part, which was,
Commonwealth,
yo retiro la oferta para quedar sencillos.
the Commonwealth withdrew its offer in this case.
La fiscalía retira su oferta en este caso.
Is this a one-day trial, Mr. Stockton?
¿Eso sería, señor Stockton, un juicio para un solo día? Sí.
I would like to schedule this on the second day of the key trial, if that's possible.
Yo
Sí,
quisiera
claro.
poner esto en el calendario para el segundo día del juicio en el caso Key, si fuera posible.
We can do that then.
Pues hagámoslo entonces.
We have Commonwealth versus Foster set for the 22nd.
Tenemos
Is that gonna
Kentucky
go-
contra Foster puesto para el día 22. ¿Esto crea alguna dificultad?
I don't see how it can go 2 days.
No,
Well, that would put you in
no
the
veo-
same situation.
no.
Yeah, I'm already ready for Foster, and it's a lot easier case to try.
No veo que pueda durar más de 2 días. Yo estoy ya preparado para el caso Foster y este juicio será mucho más fácil.
January 23rd.
Lo fijamos para el día 23, el 23 de febrero.
What time was that, Judge?
¿A qué hora, señor?
The 23rd.
Yeah.
El 23,
We
sí.
come in for trials at 9 o'clock.
¿A qué hora? A las 9 será el juicio.
Okay, you just said you were setting it on the second day of the Foster trial, so I didn't know if. Okay.
Bien, usted decía que lo ponían al calendario para el día 2 del juicio Foster, así que no sabía yo la hora.
Thank you, Judge.
Now, who's gonna be, like, we'll need to have you an interpreter here for your client on that.
Bien,
day.
gracias.
You'll have
Sí.
to all-
Necesitan intérprete para tenerlo aquí para su cliente ese día.
And there'll be a court interpreter too, but I understand we have to have 2 interpreters for that. Is that your understanding?
Y habrá un intérprete para el tribunal. Tenemos que tener 2 intérpretes. ¿Es lo que usted entiende?
Yes, Your Honor.
Yeah, I expect you
señor.
to make arrangements for Office of Public Advocacy to have your client's own interpreter here that day.
Sí,
And
piensa usted
Clerk's office is responsible for.
tendrá que hablar con la oficina de abogacía pública para que hagan los arreglos y también el secretariado del tribunal para que arreglen ellos.
Well, we received notice that there's reticence for people to come here to have interpreters, but I'm not going to try a case unless I have an interpreter present in person.
Hemos recibido notificación que la gente es reacia a venir aquí para si hay intérpretes, pero yo no haré juicio del caso a menos que haya intérpretes acá en persona.
As far as your interpreter, now the court interpreter is a different thing. They can listen, but your interpreter, in my opinion, needs to be available to go back in chambers with you or back in the office with you and have confidential conversations during a trial. I don't know if that will happen, but it's a possibility.
En cuanto a el intérprete de ustedes, usted tiene que tener un intérprete acá para que pueda acompañarlos allá atrás, que si tienen que hacer conferencias en privado, confidencialmente, etcétera. Pero en cuanto, es lo que yo entiendo, pero en cuanto a intérprete para lo que es el juicio, ya es otro intérprete diferente.
My main DPA office is telling me the same thing with regards to in person, when I try to have one available.
Well, here's the thing about it.
Mi
I
oficina de supervisoria me está
Your
diciendo
client
lo
of
mismo.
that, and he waives the personal presence of an interpreter here. I'll let y'all make that defense decision, but I'm not gonna do it unless I have a waiver to do it. You understand what I'm saying?
Yo, yo le voy a permitir, pero eso
I'm
como-
not making, the Commonwealth shouldn't be expected to make it. That's your business, okay? If that's okay with your client, we'll roll, okay? Thank you.
Thank you, Judge.
Did you get the date, sir? He understand the date?
¿Usted entendió la
He
fecha,
has
señor?
an acquaintance with him that I'm gonna give the dates to that speaks English.
Tiene un conocido que él le voy a dar las fechas, él entiende el inglés.
January 23rd,
23 de enero.
trial day. You be in conversation with your attorney and be prepared on that day. Okay, thank
Fecha
you.
del juicio. Venga con su abogado, estése preparado para ir a juicio esa fecha.
Noah Stockton. Noah Stockton.
Your Honor, did you need
Says
the interpreter
other
to
hearing.
remain?
Judge, I think he was,
Thank you, ma'am. You may be excused.
Thank you.
Noah Stockton.
Judge, Mr. Stockton was on to tender plea agreement paperwork. I have that paperwork, not,
Where is Mr. Stockton?
he's in rehabilitation. I took the paperwork to rehab and had him executed in London, Kentucky.
That's all the motion for was the documents executed correctly.
Oh, they were not executed correctly the first time?
That's correct. He's already in his plea.
Okay, and they're in conformity with the plea entered?
Yes, Your Honor.
Okay, thank you. Kyle Thomas. There's an active warrant out for Kyle Thomas. Mr. Stockton.
Yeah, we'll put him in CIC.
John Tucker.
Same, Your Honor, we'll put him in.
Sabrina Wade. The expungement, is there any objection to expungement? We'll
No, Your Honor.
enter the order. Let's go to Russell County Detention Center. Russell County, Stephen Bridgeman. Commonwealth versus Stephen Bridgeman, 22 CR 0069. Motion. It's a pretrial conference. Mr. David Cross is counsel. Also a motion for shock probation filed by Stephen Poindexter, Attorney Civil.
Judge, in regards to,
You're gonna have to speak up.
in regards to 22 CR 69, the Commonwealth and I have reached an agreement, a plea agreement for Mr. Bridgman.
Has he executed the plea agreement papers?
He has not yet. We just reached this agreement today.
Does it include the motion for shock probation being
I think the
waived?
council's married, Your Honor, but I have to sign a copy of that plea.
Okay.
What about the motion for shock probation that's pending? Is it addressed in the plea agreement?
It is not, Your Honor.
Mr. Poindexter filed that in 23 CR 0001, which I guess was a plea that Mr. Bridgman entered after the previous indictment, which was 20 jury trial.
And then I received some correspondence.
Yeah. You gonna tell me about that?
Yes, Judge. So we filed a motion for shock probation. Mr. Bridgman would like to be assessed for drug court.
Well, no. I'm talking about, is Mr. Cross standing in for Mr. Poindexter in 23 CR 0001?
Yes, Your Honor.
Thank you for allowing me to know that. It's always helpful. Okay, now, Mr. Bridgman, were you born in 1960?
Yes, it was.
Last four digits of your social security number is 6692.
Yes, it is.
Okay, is this gonna be, this is a felony plea, of course. A motion has been tendered, sir, that says you wish to enter a guilty plea. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 22CR0069?
Yes, I am.
Is your judgment impaired today in any way?
Yes.
Have you discussed the charges with your attorney and you're satisfied with her advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about the case?
Yeah.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. You have the right not to testify against yourself. No one can make you say anything. Right to speed trial by jury. Right to be represented counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. You have the right to produce evidence. Right to call witnesses in your favor. Have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and a right to require the Commonwealth to prove on reasonable doubt that you're guilty charges. But you understand that by entering a plea of guilty, you give up all those rights. You understand that?
Yes.
Now, I may consider the Commonwealth's recommendation, but I also may apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation report from probation pro. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. You understand that?
Yes.
Do we allow Mr. Stockton to get behind the microphone? What is the Commonwealth's recommendation?
Your Honor, the Commonwealth would, upon a plea of guilty possession of controlled substance first degree, recommend a sentence of 1 year to serve. This 1 year would run consecutively to the 5-year sentence he received in a jury trial, indictment number 23CR1, for a total of 6 years. The Commonwealth would oppose probation unless we address these cases in total, and all evidence in this case would be destroyed.
Is that your understanding of the recommendation?
Yes.
Are you pleading guilty because you didn't commit the act that you're charged with in this case here, which is 22CR0069? Are you pleading guilty because you didn't commit that act?
No.
No?
Yes.
We got two choices. We got one no and one yes, so I'll go with the yes. Knowing your constitutional rights, is it still your desire to give up those rights, enter a plea of guilty, and allow the court to fix your punishment? Is that correct?
Yes.
You understand that a plea of guilty, any future convictions could be enhanced as far as the range of penalties. Now, you have a signed document of that, Mr. Stock?
I do, Your Honor.
Give it to the bailiff and I'll hold it on. Sir, I'm gonna ask you to identify your signature. Is that your signature right there?
Yes, it is.
Okay. Mr. Bailiff. Well, I'll accept the agreement. And is he a state prisoner now?
He is, Your Honor.
So we could waive the pre-sentence investigation report and go ahead and sign the judgment so we can be a supplemental. Well, you want a supplemental, usually we waive it if it's a state prisoner.
They'll still do this.
Yeah, I'm gonna waive it. I don't think there's been any intervening things because he's been incarcerated since the last time. Okay, sir, thank you very much. Now, the other case that we have over there is Christopher Thrasher.
Yes, Your Honor. Give me just a second and I'll go get him.
I think you got the shot probation. Bridgeman, take that too, Your Honor.
Yes, Judge, if you want to take that up now.
Well, I asked you about that earlier.
Sorry.
If it was going to be addressed in this agreement. So it's denied. And if you want to bring it back up.
It's all got fouled up because I'm not one of you, because you're filling in. Mr. Poindexter's not here, Mr. Cross is not here. So I guess I'm gonna be defense attorney and prosecutor in this case. But my intentions was, Mr. Bridgeman got a 5-year sentence from the jury. Mr. Nally, the co-defendant, if you remember, he got a 10-year sentence, pled to the arson, served about 6 months before he got out. I was going to recommend shock probation after 180 days if he complete drug court. At one point in time, Mr. Bridgeman was a pretty good citizen here, had a good construction company, and he got a foul of drugs. The jury found him guilty of tampering, not the arson, 5 years. So that was going to be my recommendation.
This was a cabin burn.
That's correct. We tried the case to the state, tried. So
Well,
I'm going to fulfill my part of the agreement and recommend it. That was part of the agreement.
well, I'll take it under submission then. You know, the problem that I've got, somebody burned that cabin down out there. And the testimony I remember is that Mr. Bridgeman was culpable, and knew all about it, was involved in it. You know, that's
That's what Mr. Howard testified.
yeah, so at this juncture, since these attorneys evidently couldn't be here, you're standing in, but it doesn't look like you know anything about this case very much. We're dropped on you. I'll take it under advisement to the next rule day. Reconsider it out of fairness to you, Mr. Bridgman, your attorneys were not here today to argue that, so I'm going to allow them to appear on January 11th to argue the shock probation situation. Okay, thank you. Christopher Thrasher.
Your Honor, give me just a second and I'll have him right up here.
What are you saying about Christopher? Okay, thank you.
Swear.
Ask her that.
She's going.
Huh?
She's going. This is on the side. She's-
So here's Chris Thrasher, Your Honor.
Okay, this is Commonwealth of Kentucky versus Christopher Thrasher, 21 CR 00114. Are you Christopher Thrasher?
Yes, I am.
Born in 1982.
Yes,
Last 4 digits of your social security number 2940. Is that correct?
yes.
Okay, we're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole and the comprehensive sex offender pre-sentence evaluation? Have you looked at both of those?
Your Honor, he has not seen, unless somebody else gave it to him, the pre-sentence report. I have gone over the sex offender report with him.
Why hasn't he seen it?
That is my fault, Your Honor. I didn't get it until today, and I expected, I assumed he would be here for me to go over it with him today, and that was incorrect, obviously.
Okay. Are you shorthanded today? Yeah. Do you have anybody that can go over and get Mr. Thrasher? We'll send over and get Mr. Thrasher and bring him over here. Jail, have Mr. Thrasher ready to be transported over here.
Yes, sir.
Send over and get him, bring him over here, and then you can go over it with him.
Thank God. There is one other issue that I would address with the court, and we filed a motion Friday. Court will recall we had a suppression motion in this case, and we are asking the court to issue findings of fact and conclusions of law.
Okay,
On that.
that'll be fine.
We would like to have that prior to sentencing if possible, so it can be in
Well, you're not
probation.
gonna get it prior to sentencing because I'm gonna sentence him today and you file something on Friday and expect me to do it today and it's not properly filed. But I will make note that we will make written findings that should be sufficient enough to preserve your appeal on that thing if you think I'm wrong. Okay, thank you very much. You just wait around.
Yes, sir.
Wayne County. Wayne County on there?
Thank you, Your Honor.
Commonwealth versus Janet Owenby. Yeah. I thought, when he said, thank you, Your Honor, I thought that meant that was there. Wayne County does not appear to be on the line. Somebody needs to call Wayne County. Okay. Okay, while we're waiting for Wayne County to get on, we got an in-person Commonwealth versus Tyler Holland. Commonwealth versus Tyler Holland. Are you Tyler Holland?
Yes, sir.
What's your year of birth?
4/22/96.
What's the last four digits of your social security number?
0698.
You're here today for sentencing represented by counsel. Did you have an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes,
Is it substantially correct?
yes, sir.
Is there any reason, counsel, that this gentleman should not be sentenced today?
No, Your Honor, and I will note, Mr. Holland is already wearing his ankle bracelet, which was, oh. I just wanted to note that he's had that on since he was, pled guilty in Cumberland County. As you ordered.
Commonwealth recommended a sentence of 8 years to run consecutively. Serve 180 days on home incarceration with the balance probated for 5 years. What does the Commonwealth have to say about this?
Your Honor, I have no problem with my recommendation. My understanding when we entered the plea was he was working at the charcoal plant.
If you want to come up here, we can't get you online. Y'all move over. Hey, move over this way. And move over this way and let Mr. Stockton get behind the microphone.
I just want to emphasize, and I've told probation and parole when they close the plant, he needs to seek other employment immediately and get other employment because that's the basis of this agreement. It's because he's working.
So he's entering a plea to Figueroa seatbelt, operating on expired license, not in possession, no insurance, operating under the influence. Is that correct?
Yes, Your Honor.
And
No, judge, no,
those are
those
dismissed. So
dismissed.
he's
Yeah, there
trafficking.
wasn't,
Okay, I got you. He's the trafficking to, he entered a plea. There wasn't a DUI.
no, Your Honor.
Now, Mr. Stockton, how are we gonna, you mentioned that this was because he's working at a chocolate plant. One of the few people we have here is working anywhere. But, so how's that gonna be included?
Well, it's not his fault that the plant's going to close, but I've told probation pro and I've told Mr. Holland that he needs to get other employment immediately so he can keep his life going straight. Idle time is the devil's workshop, my grandma used to tell me, and I agree with that.
Okay. And it says to run consecutively with what?
It'd be a tampering with physical evidence, 4 years, and trafficking for 4 for a total of 8.
Top. Okay, he's getting 4 years on the tampering with physical evidence. You dismissed the persistent felony, correct?
Yes, Your Honor.
And trafficking for a total of 8 years. Subject to that condition, the employed. Special emphasis on this employment, okay? You need to meet with the probation parole officer. Got another head up? Commonwealth versus Robert Myers. Commonwealth versus Robert Myers. 21 CR 0081 and 23 CR 0036. You're here today for the purpose of sentencing. Have you had an opportunity to look at the 2 pre-sentence investigation reports done by probation parole? Have you? Can you speak up a little?
Yes, sir.
Okay.
He's in a lot of pain.
Yeah, well, these are voice activated if you don't say something.
Make sure you get up close to him.
Okay, is there any reason why this gentleman should not be sentenced?
No, Your Honor.
21 CR 0081, the Commonwealth recommended and you agreed to sentence of 5 years probated. Sentences run consecutively with 23 CR 0036 and 23 CR 0036. The Commonwealth recommended a sentence of 5 years to be supervised. So is that 10 years? 5 on top of 5? I'll go on consecutively. It's 5, 2.5 on 2.5.
Yes.
So he wasn't sentenced to 5 years. He was sentenced to 2.5 on each one of them, and they could be consecutive.
Correct.
Okay. Okay, we'll impose that and you meet with the probation parole officer. What the court costs? $155. You should pay the court cost $30 a month to get that paid starting 30 days from today, okay? Okay. We're ready to go to the Clinton County Jail. Clinton County Jail.
Markham and William Shepard.
Okay, William Shickles, are you here? William Shickle, and then we'll get to the jail. The Clinton County Jail needs to be ready. Commonwealth versus William Shickles. Is the purpose of, for the purpose of arraignment. Yes, sir.
I'm on it tomorrow. The motion for me to come up here. So, Judge, it's my understanding and that, I apologize, what's your name, sir? Condry. That Mr. Condry is wanting to be removed as.
Okay, well, Mr. Shickle is present in the courtroom. I'll sign and release you. He's in custody. Okay, thank you.
Thank you.
Commonwealth versus William Shickles for purpose of arraignment. This is 23 CR 0052. The grand jury of Clinton County has returned an indictment charging you with trafficking in controlled substance first degree. possession of controlled substance in the first degree, methamphetamine, operating a motor vehicle on expired license, and possession of drug paraphernalia. You understand those charges? Yes. Okay. We have a reciprocal discovery order I'm signing. We'll be here on January the 5th for the negotiation date, and the next trial date, the next pre-trial conference date here is on January the 11th. Okay, now since we have one bailiff here, I need some cooperation with you here. I want, this gentleman is in custody. Since we don't have anybody to watch him or transport him, he needs to be cuffed.
Judge, I would ask, and I
Well, I'm
know,
not finished yet. You can ask something when I get finished, okay? So when we get finished with him here, he needs to be cuffed until they come up and transport him. Now, you've got something to say.
and Judge, it was in relation to the cuffing. Judge, I know we didn't hear a reason as to why.
You didn't have to give a reason.
Well, hold on, let me talk, okay? Judge, we would ask that Ms. Shekels be permitted to stay out on bond. He would
Well, I'll
even
be
agree.
glad to do a bond review if you want to file a motion for bond reduction. I had a bond set and he was able to make it and he was free. If someone comes up here and asks to be removed from the bond, they don't have to give any reason. And I have no reason to change my previous bond decision at this juncture. So that's the way it is. Now, if you want to take a look, see if you can get somebody else that's acceptable to the court, don't say anything yet. Put him in cuffs and take him back in the room. You'll be around here to help. Okay, we have somebody else present.
Mr. Markham.
Come around, Mr. Martin.
Yeah, the bond, his bond. They'll be able to-
When the judgment will be entered, and that'll be taken care of when the judgment's entered.
Okay, I just make sure I is okay.
Have a vote here in a few days.
Okay, thank you.
Brian Markham. He's supposed to be running something. See if I don't think that was. Well, we need, before they leave with him, we need to arrange.
You did.
I don't think we finished the full form. That's history. We were interrupted by the surety before we got there.
Okay. Commonwealth versus Brian Markham, 23 CR 0050. Are you Brian Markham?
Yes, sir.
You're here today for the purpose of arraignment. Can you hear?
Yes.
Okay. Were you born in 1982?
Yes,
Last four digits, social security number 8609.
yes, sir.
You're here for the purpose of arraignment. You have the right to remain silent. The grand jury of Clinton County has charged you with marijuana cultivation, possession of drug paraphernalia, trafficking in marijuana, and another count of trafficking in marijuana, and being a persistent felony offender. Do you understand those charges? Okay. You acknowledge the identity of your client, receive indictment, await formal reading and arraignment, or plead not guilty, preserving all pretrial motions.
Yes, Your Honor.
Be here on January the 5th at 9 a.m. for your negotiation, and your next pretrial conference is on January the 11th. Okay? Thank you. Before Mr. Shekels leaves, let's make sure Did I give him a copy of the, did I give him a copy of the indictment?
You did, Judge. I thought you had finished, but
I'm satisfied with it. Yeah, he was here, he got the indictment, I'm satisfied with it. And you need to go back there and talk, probably talk to him. Is the jail on the line yet? Clinton County Jail?
yes, sir.
Daniel Duval.
Yes, sir. Your Honor.
Commonwealth versus Daniel Duval. 20 CR 0001. Are you Daniel Duval?
Yes, Your Honor.
You're on a probation revocation. What does the Commonwealth have to say? If you move to your left there.
Judge, I filed the probation, or the pretrial diversion revocation because he got a new felony case in Wayne County involving 3 counts of wanton endangerment and DUI first. And I think he's been indicted on it, so it's a F case. So however the court wants to proceed on it, but that's the basis of the revocation.
Is he being held on our paper or on Wayne County's paper?
He's got a.
And are you,
And Judge, it's,
you want to stipulate?
Judge, before I stipulate, Judge, I will say that Mr. Duval does have a bed awaiting him through ARC. This was actually negotiated through Wayne County and prosecutors and judges there. Now, he's trying to get treatment for his, admitted drug problem.
What were his charges in Wayne County?
It was 3 counts of wanton endangerment and a DUI. Wanton endangerment first, so I'm reluctant to agree to anything until those are first. I don't know how they're going to be treated. The coordinator last time I showed him still pending.
And he did this while he was out on paper from here?
Still not being mentioned.
Yeah, August 15th. Yeah. That was.
Well, you can
And I'll stipulate.
Okay, well then I'll revoke his pretrial diversion and we'll ask for pre-sentence investigation report to be done and have him here on January the 11th, and maybe the things over in Wayne County will have advanced and we'll know more about that by then. January the 11th.
Yes, Your Honor.
Joe Turner. Joe Turner. Commonwealth versus Joe Turner, 20 CR 0065. Are you Joe Turner?
Yes, sir.
We're here on 20 CR 0065 on a revocation hearing. What does the Commonwealth have to say?
Your Honor, Mr. Turner has a 5-year
You get
sentence.
behind the microphone.
Mr. Turner has a 5-year sentence on traffic and controlled substance first. He's been absconded from probation and parole since June of 2022. We're willing to submit testimony.
You want to stipulate to that?
Yes, Your Honor.
Okay, I will revoke Mr. Turner. Serve his sentence.
I'll be able to talk to you, Joe.
Excuse me?
I will be able to speak with you.
Okay.
Thank you. Commonwealth versus Ricky Wright. Commonwealth versus Ricky Wright. Are you Ricky Wright? Are you Ricky Wright?
Yes, sir.
Okay, you're here on 21 CR 0015, a probation revocation. You were born in 1963, is that correct?
Yes, sir.
Last 4 digits of social security number 6039. Correct?
6439.
Okay, what does Commonwealth have to say about Mr. Ricky Wright?
Mr. Wright has a 7-year sentence for trafficking, probated for 5. Back around August of 22, he failed a drug test. Probation Patrol was trying to get him into treatment, and he's been absconding since August of 2022.
Stipulate.
Judge, not on those facts. I don't believe that those facts properly articulate what happened.
Maybe you want to tell me what happened.
Certainly,
or you
Judge.
could offer some proof if you'd like.
Well, Judge, Mr. Wright actually went to rehabilitation through probation and parole. Once he got to the end of his time at his rehabilitation center, they tell him that he failed not one, but 2 drug tests. He tells him he has to start over. Mr. Wright leaves, reports to probation and parole, upon which they administer a drug test. I think it was 5 days later that he passes. So, Judge, this situation where the rehabilitation center actually failed Ricky, not the other way around.
Well, yeah, I've got, and the report says he absconded the last time he was reported. He failed to report on August 19th, 2022, and thereafter. So you may be correct on all that, but he hadn't reported not over here.
And I'm not going to deny those facts, Judge, but
That's
again,
enough. That's enough.
I just wanted to correct the.
What do y'all have to say? He hadn't reported in over a year. You want to come around here? Raise your right hand and swear the testimony about to give us a truth. Take a seat there, speak into the microphone, identify yourself and who you're employed in, respond to Mr. Stockton's question.
Penny Ross, I work with the Department of.
Speak up.
Penny Ross, I work with the Department of Corrections, Probation and Parole.
Okay, Ms. Ross, in reviewing your records, when is the last time probation and parole had any contact with Mr. Wright?
On Christie's report, it says on August 19th, 2022, subject failed to report.
Okay, now I can tell that from the report. But so, and then up above that, it says he reported on August 25th. Is that right? I mean,
Yeah.
I'm sorry, July 25th.
Yes,
And he was negative on his drug test.
yes,
Okay, but he has not reported since July 25th of 2022.
correct.
Okay.
Is that all you're gonna ask?
That's all I'm going to
And so, Ms. Ross, you said that was a negative screen in July 22?
Yes,
And prior to that, was Mr. Wright in rehabilitation?
on December 17th, subject arrived at the healing place in Campbellsville. On July 6th, 2022, a certificate of completion of phase 1 was entered. His discharge summary from the healing place in Campbellsville stating that subject opted to leave the aftercare program after failing 2 consecutive drug tests for THC and was directed to report to probation and parole.
And he did that?
He did.
And he was negative when he reported to probation and parole?
Yes, but he failed to report after that for over a year.
Thank you, Ms. Ross.
Is there anything else?
All I would say, no, I don't have any other questions.
Do you have any witnesses you'd like to provide?
Actually, Judge, I'm gonna call Mr. Wright.
Mr. Wright, you have a right not to say, under the Fifth Amendment of the United States Constitution, not to say anything. You gonna waive that right to testify?
Talking to you.
Mr. Wright, you do not have to testify in this case. Your attorney is calling you in order to waive your right to discrimination and testify. You want to testify?
Do you want to testify?
Well, yeah. Yes, sir.
Raise your right hand, Mr. Wright. Swear the testimony about to give the truth, the whole truth, and nothing but the truth.
Yes, sir.
Lower your hand. Go ahead.
Now, Ricky, you've heard him talk about you. I just want to ask, why was it that you didn't report to probation and parole after August 19th, 2022?
Well, I just felt the system let me down. I was negative and I completed the rehab.
Had you smoked marijuana? at
No,
the
sir.
rehabilitation?
No, sir, I have not.
And after the rehabilitation center told you to report to probation and parole, what'd you do?
I reported.
Ricky, do you have a problem with drugs?
No, sir.
Well, that could be very incriminating, you know.
I've been defense counsel and prosecutor, they both already.
I mean, I think,
Go ahead.
Hey, Ricky, would you like to get
You
some-
wanna ask him what his most recent problem with drugs? Go ahead.
Ricky, would you like to get some help?
Yes, if you feel that I need it.
Those are all the questions I have, Your Honor.
I have no question.
I'm gonna find that this gentleman, violated the terms of his probation by absconding. And maybe he can get some help at the next place he lays his head.
Your Honor, I do want the court to know and Mr. Wright to know that, Ms. Clooney hadn't asked for him to be revoked when he left rehab. It wasn't until September the 23rd of 2022, the month after he didn't report in August, that she filed this report. So he was in good graces with probation and parole when he ran off.
Yeah, he's been somewhere since then.
That's right. It's not the rehab's fault that he's been revoked. That's what I'm saying.
It's neither here nor there to me if the rehab did their job or didn't do their
Well,
job.
we wanted
He's got his own responsibility, and his own responsibility is when he was left there and told to return to probation, parole, and decided to abscond. It's a decision he made, and here are the consequences. But I hope things turn around for you, Mr. Wright. Now, we've got the case that we're waiting for, I guess, for someone to be transported over here. I guess Mr. Christopher Thrasher. Do we have another case?
We got Janet Owen in the Russell County.
Yeah, we have a mental Wayne County judge.
Wayne County.
Well, Your Honor, if this opinion is not going to stipulate, the doctor is available Thursday at 12 o'clock in Monroe County. We can take that up if we have to have it here on Thursday.
I'm getting reviewed doctor's report, so
Well, you got between now and then to do it, so we'll. You want Miss Owen to be transported over there? Mr. Stockton, on Miss Owenby that they haven't had an opportunity to review, she is in the Wayne County Jail. Do you think it would be appropriate for a transportation order to be issued to have her in Monroe County for that?
I can do that.
And you're gonna have the doctor online?
Online, it'll be online.
Okay, on a Zoom thing. So you might not get a chance. Are you gonna talk to her before then, Miss?
I can talk to her today.
Oh, Miss Owenby, you talk to her and you see if she wants to be transported over there that day, if you're gonna call her. Mr. Stockton, if Miss Owenby decides not to attend, I'm gonna ask that the council obtain a waiver of her from her personal attendance to this competence hearing in Monroe County since it's held outside of Clinton County. Okay, thank you very much.
We do have one other criminal case. I was there. It's on the back page of the documents.
It's not on our docket, but we'd be glad to hear it.
Well, I filed a motion to place him on supervised probation because of administrative discharge.
Oh, medical.
Yes.
I think you noticed me, but I think it's conflict counsel, but I have no objection.
Tony Albertson in jail, or is he free?
He's in custody because of I can't remember as much.
Commonwealth versus Tony Albertson, 21 CR 004. Are you Tony Albertson?
Yes, Your Honor.
And Mr. Albertson here can hear what's going on now. What's the story?
Mr. Albertson.
Behind the microphone.
Mr. Albertson was in drug court, the Clinton County Drug Court, and he's been administratively discharged because he's got a bad knee and he's been on medication for it. I don't know, at one point in time, he said he's gonna have heart surgery, another point in time, he says he's not, so I don't know about his medical situation, but I do know he's administratively discharged. Judge Costello put him in jail, and I'm trying to think what the sanction was. Either he missed a meeting or something, I'd have to look, but I can't recall. Jail.
So was this a felony plea?
It was, Your Honor. So typically what we do is put them back on
What,
probation.
what was the charge you ultimately put him
I
in?
think it was cultivating marijuana.
Yeah. Oh, yeah, I thought I read those charges. That's somebody else for cultivating?
As Mr. Markham, that's Mr.
Wow,
Markham.
that's two marijuana cases. It's a rare occasion. We didn't have one. So
It was.
this was a pretrial diversion. You want to revoke his pretrial diversion on this?
It's administrative discharge, wasn't determined.
I'd like to, but I don't think I can. That's where I'm at.
And Judge, we have no objection insofar as the transfer to court to supervised visitation or supervised, family court, supervised.
Well, most people that are in drug court wouldn't mind to be transferred to regular probation with supervision. You know, and it appears what the Commonwealth is saying is because he's administratively discharged, he hasn't done a violation sufficient to rise to the level to have his pretrial diversion revoked and have a pre-sentence investigation report. Is that what you're saying? First time this has happened, really, and that I can remember.
We've had a few over the years.
Yeah, okay.
Discharged.
Well, and he's in jail for what purpose now?
Sanctioned in specialty court, my understanding.
Well, it appears to me that he's out of specialty court. I don't know.
It looks like the, order of commitment and the discharge for some of these things
So I guess it should be out. If that's correct.
on December 4th, it shows order of commitment and administrative discharge on December 4th. Same time.
What was the violation? And what was the number of sanction?
I don't think Judge Costello put us determined the number of days on it. I just told Mr. Kraus I'd handle it in circuit court.
Mr. Albertson, it looks like you might have a life sentence hanging over you. That is what I'm gonna, can y'all see him in jail? Okay, what I'm gonna do is, I'm gonna put you back on your pretrial release situation. I'm gonna let you out of jail at the end of business tomorrow, and that'll give y'all an opportunity to go down and see him, correct? Probation and parole people will do there. Now, they're gonna give you the conditions that you're gonna have to comply with, which is no drug use, no violation of the law. What about his ability to operate a vehicle? Does he have a DUI or anything out there on it?
I don't know if he has a license.
No.
Don't have a license? Okay. Y'all will go down there and see him. I'll let him out at the close of business today. If not, y'all need to see him by the close of business tomorrow. They'll be down to see you, Mr. Alderson. You need to
Okay,
live.
can I come back to drug court? Cause I really love drug court. When I get my surgery, I got to go today to see my surgeon about 3:30.
Talk to drug court about that. You're the only person that I've met that loved drug court that much.
Well,
I love drug court.
He wanted to graduate from it.
Okay,
I
well,
wanna graduate.
okay, I'll let you talk to the other judge when you get your life straightened out a little bit, see if you can graduate from it, okay? They'll
Okay,
be
thank
down
you.
to see you and let you out, okay?
All right, thank you, Your Honor. Get out.
Is that all we have at Clinton County Jail? Mr. Stockton, do you have anything else except waiting for the transportation of Mr. Thrasher? You have it, Mr. Stockton? You have
Yes, I
anything
have
else?
anything.
Okay, well, let's go off the record until Mr. Thrasher comes back.
And Judge,
Garrett versus Goodman.
this is our motion to decrease, Your Honor.
Emancipation of a child.
Yes.
Brown versus Brown.
This is an agreed order, Your Honor.
To do what?
Contempt. Agreed contempt order.
Pardon?
Agreed contempt order.
Carroll versus Block. Blocky, yeah, you wanna come around?
Your Honor, this is a motion holding contempt. This case originated from Mississippi. The Timothy now resides in Clinton County. The arrearage is over 23,000 as of December 11, 2023. So we're asking you to purge himself of contempt by paying $1,000 on or before January 10th, 2023, and then remain current and pay $25 a month towards his arrearage.
$25 a month.
He would have a current support of $480 per month.
Plus 25.
Yes.
How much is the arrearages?
23,000.
Well, I mean, one thing about it, if you live long enough to pay that arrearage, you know, it'd be a long life at $25 a month.
Once the current support stops, we can raise the arrearage amount, but not.
I got you. I got you. Okay. What do you have to say, sir?
Okay, I have four children, not just two. And my son has a skin condition that needs.
Go over behind the thing.
My son has a skin condition that
Which
needs.
son? I don't know which son.
My latest son.
Okay,
That
well,
lives
here,
with
let me
me.
tell you about your latest son. And if county attorney's officer, your primary obligation that you're on the child support is your first children, isn't that correct? And that obligation that is a legal obligation. And the problems we have because you decided to procreate again, you know, does not impact that. So can you pay $1,000 by?
I'm currently not working, Your Honor.
And why aren't you working?
Because my engine of my car blew up and.
Because what?
The engine in my car blew up and that was my only transportation.
Where were you working prior to that?
Tyson. It was called Keystone then, but it was Tyson Foods now.
Well, how are you gonna pay this child support?
I'm currently putting in job applications wherever I can to try to get a job, Your Honor.
Well, people will hire anywhere around here. You can't find anybody to work anywhere around here. I'm gonna, sign this. You have $1,000 paid by January the 10th, and then continue your $480 plus $25 starting the next month. Is that correct? Starting the next month, so you have $1,000 paid by January the 10th, and then after that, you commence your $505 a month. If you do not pay that $1,000 by January 10th, come into the Clinton County Jail and turn yourself in.
Okay.
And I'll keep that for 60 days. Okay. Okay. Well, thank you very much for coming.
Thank you.
Cabinet versus Davis.
This is a motion for default judgment, Your Honor.
On what issue?
Is it arrearage?
To set child support.
Oh, it's to set child support. The person didn't file an answer. That's
Right.
correct.
If you got an amount set there,
$291 per month.
and did you calculate that according to the guidelines?
Yes.
Okay, I'll take it. Okay. Armstrong?
This is an agreed order to set child support, Your Honor.
Garrett? Cabinet versus Garrett.
This is an order, Your Honor, to decrease support based upon disability income.
Cletite, is that how you say the name? Cabinet versus Cletite. What do you have here?
Your Honor, this is a motion to dismiss because the parent no longer lives in Kentucky. This case came from Alabama, or that's where he's at now, I think.
Okay. Farrell, Cabinet versus Farrell.
Yes, she's here. You can come up, you can. This is a motion for default judgment to set support. The child is in foster care for $312 per month. Do you have any objections to the motion?
Okay, who, she's gonna pay the 312?
Yes.
You're gonna pay the 12. Where is the father identified?
Yes. We're working on his case as well.
Okay.
Progress on the motion.
Where are you working at now?
I had an interview with, over there in Jamestown at the grocery store, Carver.
So you're not working anywhere?
No, I'm supposed to go for my interview next Friday.
Okay, well, you need to get up and out in front of this so it doesn't get in the rears, okay? Okay, thank you very much. Does that conclude the child support schedule? Thank y'all very much.
Thank you.
Okay, we have some EPOs that are scheduled here, or at least on the docket, whether they're scheduled or not. Flint Ray Thacker. This is Rachel Michelle Thacker, Rachel Michelle Thayer versus Flint Ray Thacker. Okay, you're Rachel Michelle Thayer, is that correct? Okay, are y'all married to each other?
We have signed divorce papers.
Do what?
We've signed divorce papers.
Well, are you married to each other?
Yes.
Okay, that you're not divorced until I sign the divorce papers or the judge signs the divorce paper. Y'all sign an agreement between each other. Okay, will you move to your left, sir? Will you get behind the microphone here, ma'am? Okay, now I have read your affidavit here in your petition. You said you're terrified of him.
Correct.
Okay, has he hit you?
He has before, yes.
How long ago was that?
Back in August.
Back in August. Now, did you file a petition for protection at that time?
I did not.
Okay, and when's the most recent time he placed you in fear? Or
The
did you
day
have a
that
You have just a general fear of him, or on this particular day you signed this, what was it that placed you in fear?
just the manipulation, the lies, the threats. I tried to get him to leave my
What
home.
kind of threats?
Um,
Well, you tried to get him to leave your marital residence where y'all were living together
Correct.
when you wanted a divorce. You told him to leave and he was resistant to that.
Correct.
Okay. Okay, where are you living now?
I live on 639.
Okay, where does he live now?
I don't know.
So he's not living with you
No.
yet? Has he been around or about you or called you or anything like that? Where are the divorce papers in line? Did you do one of these self-represented divorces, or did you have an attorney to do?
Mr. Cross is our attorney for that.
Mr. Cross, what's going on with their
We're
divorce?
waiting on filing fees and payment, Your Honor, to get it filed, but they both indicated they'd be signing it. They will sign it.
Well, you can go over to the clerk's office, they'll show you how to do it for nothing. Let's cut Mr. Cross out like they do every other attorney, and then get in a mess for not having an attorney. So when you think you're gonna have it filed? I don't see if it's not filed, how it's up here.
Well, I think they told the district court they were getting a divorce.
Well, that's not good enough to get it up here, really. I don't have any jurisdiction over this. So, I'm gonna respectfully send it back down to district court because I have no jurisdiction. Isn't that correct? Yeah. So, no children involved. They get me something up here, I'll sign it the same day. And there's no waiting. I mean, y'all been apart long enough and everything. I will tell you that you need to stay away from this lady here. You don't need to call her. You don't need to threaten her. You don't need to do anything. It appears to me that things might have cooled off a little bit and that y'all can get this divorce and each one of you be on your way to try to live the rest of your life peacefully. But I'm not gonna, I don't have the authority to dismiss the order of protection or to extend it because there's not been a divorce filed. So I do have the authority, however, to sign the divorce decree when it gets up here to me. Now, once the divorce decree gets signed, you're fine with there not being a protective order in there?
Correct.
Okay, and you're fine with that too, and you think you can refrain from getting around this lady and find someone who will appreciate being the object of your affection more than she does? Okay, well, good luck to both of you. Be on your way. Okay, let's go. We're a little early on the civil docket. Was that the only EPO we have? Well, it's beginning to look a lot like Christmas. We'll pick them up here in a few days. Usually when the EPOs and the visitation calls usually come. You know, watch her out of the courthouse. Okay. Gibson versus Gibson. Are y'all ready for that? What was that?
Your Honor, it's my motion, and I want to be candid with the court. Ms. Capps has raised an issue that is absolutely correct. My client didn't get in to sign the affidavit. You know, I could say we thought we'd be able to get an agreement anyway, but we're not. But I think her motion's well taken.
Is your client here?
No, he's working out of town.
So you say it has to be verified.
Yes.
What is the issue?
The issue, Your Honor, is there's two issues. Number one, they've got two children. The order only applies to one. He's been working out of town. We're just trying to establish regular telephone contact as well as contact when he comes into Clinton County.
And the judge, in response, I reviewed the original filing. It looks like it was insufficient at the time. She was never served with it. It wasn't properly filed to begin with. We have one child now that they're trying to incorporate an ad that's 8 years old. So they've just now decided to do for Mr. Gibson to take action for an 8-year-old. He's behind over $13,688 in arrears, and he's not had any consistent contact in over 8 years. So we would just ask that the court overrule the motion.
Your Honor, Mr. Gibson is like a lot of these young people around here. He's He's forced to work out of town. He's doing much better. And
Well, you say he's doing much better, it indicated he wasn't doing well at first, so what you're saying?
so we talked.
Not as bad as he used to be, is that what you're
Well,
saying?
Your Honor, Mr. Gibson is doing well by working consistently and paying support.
Okay,
now.
There are two children involved here,
Yes.
an 8-year-old
And one that's, she 10, that's what I said, she's
10 and an 8-year-old, little boy, little girl.
Two little girls.
Two little girls.
Your Honor, they had an order only applied to the one that's
Well,
now 10.
okay, well, we're gonna try to get around some procedural problems here and get down to what will make everybody, he's had very little contact with the children.
And that's not at my because it's my
Well,
client.
I'm just asking, usually it's wasn't ever my client's fault either, it's always Mr. Cross's problem or somebody else's problem. What are we gonna do to establish some visitation for the father
Well,
at some
Judge,
juncture?
that raises another issue. My client has remarried and we will be seeking probably to file an adoption petition in the very near future.
Well, you'd have to do a termination of parental
Yes.
rights first. So
Well, I mean,
she's not inclined to want to establish any visitation.
That's correct.
Yeah, okay. How does your client feel about that?
He indicated to me he's not going to, whether I represent him or whether I
Go
don't.
quietly into the night.
He's not going to roll over and play dead on a termination.
Yeah, okay. Well, it seems like this needs to have you filed your petition, your termination of parental rights sort of thing.
We have not yet.
You know, as we all know, termination of parental rights is a pretty heavy lift. I don't know, you might very well get there. I don't know. But, I know it's not directly connected, as far as that, but how much is he behind?
$13,689
Is he paying
essentially.
anything?
Barely anything, Judge.
Well, what is barely?
Your Honor, unless Angie, you've got the figures, that's good. That's something I'm not aware of.
It looks like before September of this year, he was paying $34.96, $15, $33. And then right before we start getting ready to go to court, we're paying $110.77.
Looks like he's subject to a wage assignment, I would think, Your Honor. I'm not sure. Mr. Gibson works, travels around, works a great distance away.
Yeah. You can make that much for working at home.
Well.
Is there anything I can say, Your Honor? He's my son.
Well, no, you can't say anything. But nothing's gonna happen to your son here today. There's
Okay.
not gonna be an order, so you may rest easy. What I'm trying to do, ma'am, is reach a conclusion that will be fair and satisfactory to everyone. I know, not you or the parties involved, okay? What do you think this ought to go to the commissioner to feather it out a little bit, or it doesn't seem like that there's.
Your Honor, this petition for termination, I thought this would be a simple matter, and that's something.
Well, there's some other issues besides the financial obligations,
Well,
Judge,
I'm
and that
sure
would have to
there
be
are.
figured out.
I'm sure there are some other issues, but I'm trying to get all of this into one format that we can handle the potential termination, the potential visitation, the child support. We've got things all spread out.
And Your Honor, if I may interject, I've been hired to file this motion and try to get something definitive established. I don't know if I'll be representing Mr. Gibson or not. I'm sure he'll get counsel, but it may well not be us. So as far as, I was hoping we'd get something.
Well, I need somebody that you need to go consult with your client and tell him that he needs to either pay you to represent him on everything or get somebody else to represent him on everything.
He will.
Well, I know, but we're here today. So I'm not going to enter any order that would change anything substantive today, one way or the other, because of the uncertainty of representation and the other issues that are involved. I would suggest that if you want to come back in front of me, that you reschedule something for January 11th, or if there's anything that needs a recommendation of the commissioner, you might go to him. I really don't see anything that the commissioner's recommendation is going to settle right now. You agree with that?
Your Honor, understand what the court is saying. I just want to advise the court, I know Mr. Gibson will attempt to exercise visitation or parenting time during the holidays, and there is an existing order. I
Well, I'm
hope-
gonna suspend that order. But I'm not gonna do anything permanent. Unless you've got some testimony that he's made a regular effort to see these children. I don't know if they want to see him or whatever, so.
Well, Your Honor, I know.
I'm gonna suspend the order, but allow some visitation during the holidays. With him.
Your Honor,
That's the issue, judges. He's not ever tried to really
Well, here's the thing
exercise.
about it, is I'm gonna let him have some visitation during the holidays as a humanitarian sort of situation, if we can find an agreed place where someone.
Well, I would ask if my client could give some testimony as to why he's not even been talking to the children on the phone.
And I would offer my,
Ma'am, if you say anything else, I'm gonna have you removed from the courtroom.
I'm trying to get you an opportunity to testify. Whatever. I would let her testify in regard to his efforts he's made.
Well, I'm gonna pass this to the end of the docket.
Thank you.
You go over and get control of your client's mother. Okay, Porco propane versus one Riddle and others. Okay.
Your Honor, this is our motion today. The sole motion is for the check that's in the Porco possession for some $35,000 to simply be credited to the account of defendants and not considered to be a payment and satisfaction in full. I think under the law, this is the way we have to proceed. I know the court's read the motion, but what had happened, Your Honor, is to refresh, Porco filed suit against Riddle and Renault, including Mr. Renault's wife, who's represented by Mr. Gibson. The Riddle and Renault were in the process of trying to sell their poultry houses.
Yeah.
We were having primarily discussion with Mr. Ramsey, who represented Mr. Renault. By written correspondence and oral discussion, and we're assured that when the poultry house is sold, Tor would be paid, and we had discussions about how much.
Has it been sold?
Yes,
And
yes.
they weren't paid?
Well, no, here's what happened. We were paid, but Mr. Little is available to testify if need be. But Mr. Little, not Mr. Ramsey, not Mr. Garman, not Mr. Gibson, not Ms. Capps, Mr. Little did the closing. He had been aware of.
What did he do at the closing?
Well, he called my client directly and asked for a payoff. And the lady that he talked to said, "This is what I've got. This is the payoffs," what he was told. That was not the payoff. That was not correct. It's about $30,000 off.
Anybody else have anything to say?
Judge, in response, I was originally representing Mr. Riddle in the
You
divorce
go
action.
behind the microphone.
I was representing Mr. Riddle in the divorce action, but due to a conflict, I withdrew from that, but I never withdrew from this particular issue of the civil action from Porco. And I would just argue that in response, there's no fault of my client, Mr. Riddle, as to any claimed balance is still owed. They followed through with their agreement. Mr. Riddle contacted Porco, Mr. Cross's client, got a payoff amount. They withheld that amount from the funds, and my client was not contacted and involved in any manner other than, yes, this Porco bill had to be
Who
paid.
was Mr. Little represent? Where is Mr. Little?
He said he'd come over if you wanted to get him over.
Well, not necessarily.
Well, I asked him to stay. We didn't know how long it would take.
I'd say he probably ought to be contacting his carrier right now if I was.
Well.
So the money was distributed to the sellers without taking the entire amount that was owed to Porco out. Is that correct?
The sellers check was delivered to the sellers. I'm sorry, or not the sellers, the money was delivered to Porco. I was out of the loop completely. My client calls me.
Where did the money come from?
Mr. Little's escrow.
Out of the sale of the property?
Yeah.
The property and the money was escrowed, and the amount of the judgment.
We didn't have a judgment yet. It's
Well, I'm trying to find out why anybody sent any money to Mr. Little.
because there had been a previous agreed order in their case with each other that Porco would be paid.
It's a judgment. It's agreed order.
Yeah, in the other
Well,
case, not in our case.
Yeah.
Yeah.
And so the money was sent over, and Mr. Little calls Porco to find out what the amount is, and they tell him a lesser amount than had been forwarded to him. Is that correct?
Mr. Little calls Tracy Hay, who has worked there about a year.
At Porco.
At Porco. And
Okay.
Tracy pulls it up on the computer.
And gives him what amount? I don't care how she did it. She
Right.
gives him an amount.
Which is incorrect.
Is it, and it was less than that he had in his escrow account.
No, he had sufficient funds in his escrow to pay everything. Because these folks got
And
a
so
distribution.
he distributed his escrow account after setting a certain amount aside for Porco. Who got the $10,000? I'm a little confused.
You mean the third? Your Honor, Mr. Little issued Porco a check.
Okay, well, wait just a second. Let's go back to number one here, okay? You got Porco filing because nobody paid from the gas that warmed the chicken house, okay? And there was an agreement between the parties to pay Porco when the property sold.
An agreement between these parties. And we just treaded water on our lawsuit. We just waited on their
Between
assurance.
Porco and who was the agreement?
Well, Your Honor, there's an agreed order in the case of Reno versus Riddle that said Porco would be paid X number of dollars. Now, Mr. Ramsey and I have discussed this case for 2 years, and the agreement between us was when the Folger houses were sold, Porco would be paid. We never agreed on a specific amount above the 35,000. But that was what Mr. Ramsey.
So there was an amount above the 35,000 agreed orders. Is that what you're saying?
Yeah.
Judge, I would ask that you have the clerk's office bring over 18 CI 43.
Yes.
So,
That's good.
because I didn't receive a copy of the agreed order, and I think Mr. Riddle was represented by different counsel that's not here today in that action. So I can't speak if my client
Who was
actually.
that counsel?
Mr. Hartley,
Perhaps you can shed some light on this.
I'll try, Judge. There was.
Speak up just a little bit.
Yes, sir. This is a lawsuit of Porco against the three individuals. All the parties denied that there's any money due. There's never been a hearing on it. There was a motion for summary that was denied. We filed a counterclaim or a cross claim. That action stopped.
Who do you represent?
I represent Stephanie Renault.
So these individuals together own the chicken house?
They did, no, an LLC owned the chicken house. They were 50% ownership of Mr. Riddle and 25% each the Renaults.
So the LLC, which they owned the chicken house?
That's correct. They didn't sue the LLC. We had a summary judgment on that. The law was that it had been administratively dissolved, but if you reinstate it, it goes back to the ownership of the LLC and the debt is to them. It wasn't administratively brought back up. But in the divorce case where Mr. Riddle was brought into it, there was an agreed order entered saying that if the property was sold for $850,000, then certain amounts of money would be paid out of that. The property was not sold for $850,000.
How much was it sold for?
$750,000. And at the time that the sale occurred.
Well, but it says the party shall sell the business assets for no less than $850,000. And I would assume that anybody that entered into that agreement was protecting themselves to make sure that it wasn't sold for, and when it was sold for less than that, it probably voids the distribution agreement.
Yes, sir,
Because
that's our
they were out of agreement. Do you agree with that, Mr. Cross?
Your Honor, I think it's a valid point as far as.
Get behind the speaker.
Yeah, the property was in fact sold for a lesser amount, but I think you can see that it's clear these people were acknowledging this was a valid debt that they wanted.
I'm not getting to that point. I'm trying to get to how much you're representing Porco.
Yes.
How much did you get right now?
$35,000.
And how much do you want?
Well, it's not what we want, it's what we'd settle for, but the whole thing would be $66,000. But we're not.
If you got proof that gas to that amount
Yes.
was,
Oh, yes.
okay, is anybody challenged that they provided gas of
Your Honor,
$66,000?
Mr. Riddle at all times has acknowledged the debt. Mr. Reno has acknowledged the debt. I don't believe Mr.
Who
Gibson.
bought the chicken house?
LLC.
York. Lance York. York, Commonwealth bought the chicken.
Another LLC bought it.
No, it was to Caleb York and so. It wasn't Lance, it was.
Well, they weren't previous owners of the previous LLC, were they?
No, they were
So
not.
they formed a new LLC to buy the chicken.
I don't know if they did that or not. They signed an agreement to purchase in their individual names.
Well, what was this property upside down? They sold it for $750,000 or so.
No, there was remaining distribution to be to the three LLC members.
What I'm asking is, this agreement here said they shall sell the business assets for no less than $850,000, and it lists of some distributions that should be made, okay? But actually, the property is sold for less than $850,000. It's sold for $750,000. Did Farm Credit get their money? Farm Credit Mid-America.
I'm confident they did, Your Honor.
Okay, or it wouldn't have closed. Did Farm Credit Mid-America get the $12,000? Did People Bank get their $10,000? Did People Bank get their other $10,000? Did Jason Gibson get $100,000? Did Port and then we had United Propane. Did they get any money at the closing?
Questions for Mr. Little, Your Honor.
Do what?
Questions for Mr. Little, who handled the closing.
Well, were there any excess funds to go to the sellers after everything was paid?
There was.
And so does he still have those excess funds in his escrow? He distributed the excess funds. So none of these other people are really involved in the thing, other than the fact that there were funds that were supposed to pay Porco off, and Porco received a lesser amount than they believe they're owed out of the distribution of the sale of property.
Yes.
Okay, well, you could have said that in a simple form, except what days we met and all that kind of stuff, but I pretty now we're down there. Do y'all agree that that frames what the deal is? And you're saying it wasn't your problem, your client. Does anybody represent the purchaser of the property?
No, Your Honor.
Okay, the purchaser probably got a clean title to it for $750,000. Now, the sellers of the property, what kind of distribution did they receive? Who is it? Are they the sellers here?
Yeah, Mr. Douglas.
Okay, you own a portion of the LLC. You own 25% of one of the LLCs, of the LLC. And so did you receive distribution? Okay, and how much distribution did you receive? And so so you could multiply that by 4 and say that there was about $45,000 distributed to the sellers. Is that fair?
Judge, I think it would have been broken up by 3.
3.
It was 4.
50% to Mr. Riddle
That's
and
what-
25
To each one of them. So 4 times the $11,000 and change would be $45,000. And you're claiming that Porco is entitled to virtually all of that.
Well, we were entitled, our position is the $35,000 is not payment in full. What we're asking the court to do today is order that we could cash this check we have in our possession and credit it to the account.
Without saying it's payment in full.
That's correct.
This agreement said $45,000, but that was predicated on the agreement that they sold it for $850 and they sold it for less than that.
I'm confident, Your Honor, if my
Okay, now
client
you have a separate litigation going on in which Porco is still suing who? Who's left to sue now that the farm's gone?
Well, we've got all these folks named individually. We just sat on it for over 2 years because we had faith and reliance on opposing counsel and on the good name of Riddle and Renault that they would pay this, as they said they would do.
Well, there's $44,000 that was distributed from the sale of this. Is there sufficient money there to satisfy your client?
More than enough.
Okay, now therein we get the problem there. I would suggest that I pass over this particular situation and the beneficiaries of those payments get together, Mr. Cross, and satisfy your client. You understand what I'm saying? So the people that got the $44,000 and these other folks really don't have anything to say in it, you know.
Prior to the sale, we filed a cross claim on the Porco claim. My client is in no really business dealings with that at all. We asked if there was any now said to do that my client be reimbursed for those. Prior to this sale, we have a written document from both of the other owners that says she owes no other money whatsoever. So essentially, we're out of this litigation.
Who do you represent?
Yes, we're done.
You wasn't standing over there next
I
year.
won't
I
go
was,
here.
So who signed that to you? For you, just tell me.
The owners of the property,
The other owners.
the other two owners.
Okay, there are three owners, 50, 25, 25. Okay, I don't care. See, I understand what you're saying. 50, 50, 25, and they indemnified her.
They did.
They indemnified her.
Yes,
Well,
sir.
here's the problem I have. That's a problem they have among themselves, the four owners. It doesn't affect Porco. She was a beneficiary of the gas if she was the owner of a fourth of, to keep the little chicks warm and everything. So there's $44,000. Now, if she wants to recover her, whatever she has to throw in the pot from them, that's a separate issue as far as I'm concerned. It wouldn't affect Porco. Porco was, maybe I'm wrong about that. Who do you represent?
Judge, I'm standing here for Mr. Ramsey.
Well, he's not a party yet.
Not yet. My ears were parted.
Oh, man.
Yeah, okay, and who does he represent?
He represents Joshua, we both are.
Okay, a four-term. He says 50 and a quarter and a quarter.
Yeah, see that, him and Stephanie both on.
Quarter, yeah. And they were married at one time?
Yes.
Yeah, and so they split this thing, so quarter, and a half. So, and you know anything about this indemnification that your client supposedly signed?
No, Your Honor.
Take a look at that.
It's actually a claim that's pending in the Porco claim case, Judge, and I'll file a motion on it. Oh, sure, absolutely. Sure have.
Your Honor, let me.
And you're claiming your client owes nothing more.
Correct.
And why is that again?
Because prior to the sale of this property for $750,000 less, we requested and got an agreement from the other LLC owners that my client would owe absolutely no other amount of money.
Okay,
for
but
any
that
kind of
doesn't
debt.
affect any claim that Porco would have against the entity or the client. That's the internal agreement as far as distribution fund between the three owners. Isn't that right?
It is,
Yeah.
and that's part of our lawsuit.
Yeah.
Our cross.
How's Porco involved?
It's a cross claim against them in the Porco lawsuit.
Well, against who? Not against Porco.
Against the two other owners.
Yeah, well, so it doesn't involve Porco.
No, sir.
Porco wants their money, and the question is, who's gonna pay it? Whether your client has been released by this agreement with the other two owners, I understand. And probably they were wanting her to walk off so it would be easier to sell the property, right? Who knows? Okay, so what are you gonna do now, Mr. Cross? Are you gonna sit down with the folks and try to negotiate?
Your Honor, I've made some initial overtures. I haven't heard a thing back from anybody else, but after the court's opining from the bench, I hope we can all sit down or get this worked out. Porco will be very reasonable about this. in my opinion.
It's always good to elevate the court's opinion of your own client.
I've never
They're
known a
being
court to be
reasonable
nothing
and
but
great
reasonable,
people
Mr.
and
Craig.
that sort of thing. Go to church frequently. Okay, I'm gonna hand that back out there, so I don't lose. Well, I want y'all to either send me an agreed order that this thing has been taken care of, or be back here on the 11th. And I understand your position, so when this lady sits down with those other folks, they need to understand that they probably have an agreement. Her presence might not be necessary if there's enough money. I don't understand though, that I do think Mr. Little needs to be involved in it somewhat. Because he was the one that released the money, but there wasn't a judgment. There was just an agreement, but the agreement was to the extent of 45,000. Y'all just get 35.
Yes, 35,414, I believe, Your Honor.
And then you've got the issue of the rest of the amount. And that was all during while this LLC was still running the chicken house.
It had been dissolved
67,000.
during the pendency of some of the accounts were with the LLC and some were later. Some were after been dissolved.
It was actually reinstated, Judge, from the time we.
That may be.
Yeah, you said that earlier. Okay. Okay, does anybody have anything else to say? We have a game plan now?
Well, Your Honor, back to the original motion, you know, it's close to Christmas and Porco's got all these guys out there working. Can we cash the check now and not be considered paid in full? That's what the motion is.
I don't think there's ever been a determination how much is owed, Judge. Everybody has denied we owe anything.
No, they've not, Mr. Gibson. Your client has never acknowledged owing a nickel, but the rest of these people have. So
I
I have
read
to
the
correct you.
petitions and you sent discovery and every one of them said, no, we don't owe
Well,
anything.
I know I can rely on Mr. Ramsey, okay? Absolutely.
Talking about documents.
So, Your Honor, they've made a payment. All we want to do is credit it and know that it's not paid in full.
Well, they didn't make the payment. The payment was escrowed out of the closing, correct?
Correct.
And they they did an agreement that if it sold for this amount, that they would pay that much, probably to help the closing. Would that be a
I would say that's
fair
correct.
statement? That so it was an amount in compromise,
Yes, sir.
if that's amount. So it would appear to me that might be what Porco gets is what was in that agreement at 45,000. But I'm not going to
I think
prejudge
that
that.
would be quite just, Your Honor, if we get to $45,000, Porco's willing to walk away.
Well, why don't y'all? That's just $10,000 difference.
Yes.
Would it do any good for y'all to go back there and contact somebody to see if you have authority to come up with? She's been released, so the 10,000 would be a third and 2/3, wouldn't it? If she's been if everybody else released her, so you're talking about $6,666.66 and $3,333.33, correct? That would make Porco happy and make this all go away. Could y'all go make a phone call, see if you could do that? Or is your client, you think, not willing to do that?
My client, as you indicated, we.
Yeah, I mean, but I know you're out, but your client's willing.
I don't have a number for Mr. Renaud. I don't have a relationship with him, but I would just.
Well, somebody should have been here with some authority today. So where's Mr. Ramsey?
Mr. Ramsey, is at the night doctor appointment. He got set out for a couple months.
Yeah, well, why don't you call Mr. Ramsey and see if you can get a phone number for your client to see if they're the ones that just own a third now, right? As far as this obligation. If she's been released, somebody owns 2/3 and somebody owns a third. Who do you represent?
I represent Mr. Riddle, but of course, we would argue that Mr. Reno is in with 50/50. They both signed that agreement releasing her for me.
I think Ms. Katz is right.
I understand what you're saying. That could be true. Well, you have 250, you have a 50, a 25, and a 25. And the people with 50 and 25 release her, or just the person with the other 25 releases her?
No, both really, sir.
Okay. So they both released her. So when they released her, who assumes her obligation? You saying that
I think
obligation is
Mr.
shit?
Rideau does,
Why do you think that?
because if not for his marriage with her, he would.
Well, if not for their release of her, they wouldn't be obligated for any of it. So it could be, they could have some advantage to them somewhere to release her to facilitate the closing. I don't know why they did. But if, you know, the thing about it is, the other 50% owners, your clients didn't have to release her. I mean, he could have said he was gonna assume the 25% that wasn't covered. You follow what I'm saying, Mr. Cross? But these other parties, let me see that agreement again. You got there. Jeez, that people. Well, the parties further agree that Stephanie Renault is not responsible for any and all of the debts owned by R.R. Poultry, Mr. Joshua Renault, and Mr. Dwayne Riddle, and hereby hold her harmless. And Dwayne Riddle agrees to that. So Dwayne Riddle and Joshua have released Mr. Renault, but it doesn't say that Mr. Riddle will assume any more of the thing, what you're saying, than the 50%, and it doesn't say Joshua will receive. So, but somebody is responsible for paying the 25% that would be attributed to her ownership. You follow what I'm saying?
I would, and if I could address Judge, the way that's worded, the way you read it, that could be any other unknown debts, which she was well aware of this because she was sued individually. So I don't know that that agreement actually covers the debt to Porco to release her, because that's signed after the fact of this debt being acknowledged.
The amounts of debts that were to be paid were specifically set out
They
in
were.
the document. No, I'm talking about the new sales document.
They were. I read it to you a while ago. If it's sold for $850,000, is that a different document?
There is one. The actual sales document for the $750,000 had these amounts listed in it. And we also had some.
Okay, where is that document? So the $850,000 document agreed was modified, you're saying, by the $750,000 sale agreement.
This is a document completed by the sales agent.
Okay.
Closing settlement statement. I believe it has these documents set forth in there, and we also have documents.
Let me see that.
Here's the documents provided by them as the amounts to be paid that are covered underneath that.
Porco, $35,000. UPG, $21,000. Gibson, $100,000. Farmers, $61,62. Kyle, $81,84. Who is Kyle? Kentucky. What does Kyle mean?
I have no idea, sir.
Peoples, 7,500. Probably an acronym for somebody, right? Okay, well. You've heard an amount that would satisfy Porco, which was a reduced amount. I would suggest that we try to get an agreement between the other two owners as they've released this lady to see if they're willing to chip anything in to settle this thing. And if they're not, I can have a full-blown hearing on the thing. And we'll start with square one on the thing. That last that last salesman agreement was helpful. But you had a moving target here on what it was gonna bring and who was gonna get paid what. Had two people who were divorced and you wanted to clear one of them probably so she'd sign the documents because she didn't want to expose herself to some unlimited debt that, since she wasn't directly involved in the management of it. Is that?
That's exactly correct.
Yeah, okay. Okay, well, see if y'all can work something out. I would suggest that you call Mr. Ramsey and see what contribution that they might be willing to make this thing go away. And all of them got out better than they could have.
Probably come back on the 11th.
Yeah, unless you send an agreed order, which would be preferable.
Thank you.
Okay.
Thank you, Judge.
Yeah, Baker versus Baker. Okay. And Ms. Capps, you have, is your motion?
Judge, I think it's Mr. Wilkerson's motion.
Judge, we filed a motion to enforce the settlement agreement in this matter. The parties informally mediated this, had a mediation conference.
What do you want to enforce?
Enforce the agreement as outlined.
Which portions of it? Tell me specifically so we can hone it down.
So specifically, the ones that need to be omitted, the only thing that is in contest is that there was after the informal mediation, there was a subsequent term that was thrown into the mix.
Tell me what it is. Tell me what you want. Tell me what
$500 per month, Judge.
For how long?
Is been asked by Miss Baker in perpetuity. So that's her request, even though the parties had an agreement that the only financial obligation as far as that was concerned was half of Mr. Baker's retirement account. As stated.
Quadro, did you have a quadro?
The agreement was following mediation that
Mr. Cross, you're key in the microphone. If y'all, there's a library, if y'all want to step back in the jury room and talk there.
That the quadro would need to be drafted per the Mr. Baker's employer's instructions. That was agreed upon. That was set forth and presented to Ms. Capps, and then.
Okay, well, what you're saying is, what relief do you want?
The relief is to enforce the settlement agreement that was brought.
And leave out the $500.
Leave out the $500 per month ongoing maintenance.
It wouldn't be maintenance, would it?
Well, that was that was how it's
what you
couched.
called it? Okay, now you tell me your side of it.
And Judge, we did informally mediate. We had discussed.
Tell me what you want.
Well, we would like for the discussion that the parties had after.
No, tell me what you want.
We want the $500 a month for 5 years.
What does that represent, the $500?
That would be maintenance.
Okay, and was that in the order?
There was no order, Judge.
There's not been a divorce decree?
No,
So they're not divorced yet?
no, they're not.
Okay, so the issue is whether or not she's entitled to $500 a month maintenance. Is that the issue?
That is not the issue. The issue is these parties have entered into a formal a contract wherein the parties left with a duly enforceable contract where they had agreed to all property issues. And then it was sometime after the fact that Ms. Baker gets cold feet after the deal had been done and then makes this new request.
You have a signed separation agreement?
We do not, Your Honor.
What are you talking about?
I filed a motion, Judge.
Now tell me what you're talking about.
I'm stating that.
Do they have a signed separation agreement?
Correspondence, Judge, the exchange of mutual promises is a
That would
contract.
be no.
No,
They
sir.
don't have a sign. Now we can get to this other stuff, but we'll make it through this laborious process that I go through by getting my mind into this thing. If you'll just answer the question straight, they do not have a signed settlement agreement, but what they do have is correspondence, which you say shows an agreement of the minds between the party contractually on this divorce. Is that what you're saying?
That's correct.
Thank you. Okay, and what do you say about that? You say that's not enforceable?
Judge, I say that's not enforceable because as soon as the the informal settlement was over, the two parties contacted each other, so there's no longer a meeting of the minds. And he even exchanged text messages with her saying that he would agree to do it. He just didn't want to put it in the paperwork. So therefore, our position is it's not.
Say that? I don't want to look at them right now. I'm just asking them be a yes or no,
We do have text messages where he is agreeing to pay her
which
a
would
certain
serve
amount.
as a modification, you're saying. of the
Yes.
agreement, before it's ever entered into a recognized separation agreement between the parties.
That's correct.
Okay, of these parties, how long does she want, I mean, what's the least your client would take? She wants $500 a month.
$500 a month for 5 years, Judge.
Well, she probably won't get that, so what's she going to take? Okay, well, I'll just tell you what I'm gonna do. I'll just set y'all before the commissioner, and there's no agreement of any kind at this, in my mind, but we'll do evidence of the agreement, to see if he decides there was an agreement between the party or any modification or recommendations on that. But I will tell you that it would be awfully good for everybody involved if they could reach an agreement before the holidays and enter the new year with a fresh start. So if you lock up, you might end up with less than you would if you made an agreement. So you need to call locked up?
Yep.
Okay, well, I know how to handle that. I'll just listen to what I had an old law professor said. We'll just go ahead and hear all the evidence and let them lay where Jesus plains. So you'll get something with the commissioner soon. There won't be any payments to be made.
Judge, we do have an existing temporary agreed order that was entered in December of 2022 when we were before the DRC on temporary motions, where he was ordered to pay temporary maintenance while this was pending.
Well, it appears to me that she's delayed the settlement of this thing maybe unreasonably. How much a month has she been paid? What, has she got the quadro payments haven't started yet?
No, they have not started yet, Judge.
Okay, well, how much is the monthly payment now?
Bear with me, I'm going back through $750 a month.
Judge, if I may, is with regard to the domestic relations commissioner, our motion is to enforce the settlement agreement. It's a point of law.
There is no settlement. That I see.
Without any, I've seen nothing to the contrary, Judge. We filed a written motion with, set forth the facts with exhibits. We set forth the correspondence. We set forth the law with regard to these settlement agreements and construing them to be enforceable. I have received nothing with regard to any countering evidence to suggest that they have not had, that they weren't.
So do you have any sign, so you're taking an oral statement that is supported by text back and forth?
No, Your Honor. This is with regard to communication between counsel. After the mediation, there was an email sent that set forth the exact terms that the parties had agreed to at the informal mediation agreement. The very next, within short order, there was a properly written memorandum which articulated it in style.
You said informal mediation. Was there a mediator there?
No, that was a discussion between counsel and the parties, Judge. And like I said, then as soon as they leave, they start having communication to modify what we thought it was an agreement. So I am posing there's no agreement or meeting of the minds at this point.
I'll review your motion. But I'm not inclined to believe that when parties negotiate things and they don't reduce them to writing and have their clients sign them while the iron is still hot, that they can come back and enforce it when they walk out of the office and then start talking to each other and have a disagreement on what they wanted with that sort of thing. It would appear to me that it should have been reduced even if it was on a legal pad, and make both of them sign it right there. So I'll read it. If you got enough law in it, I don't think that's what the law is. I might be wrong. I've been wrong. And once. You have anything else?
No, Your Honor.
It just, how much, where did you work, sir?
Tyson. Tyson Food, Your Honor.
Tyson's Food, and that's where, are you retired yet?
Oh, not yet, sir.
Well, I have to ask because people retire at all different stages.
I'd like to be now.
I'm 70 and I'm not retired, so I found that out when I had some medical bills and everybody thought I was on Medicare, and then I got busted with a copayment that I wouldn't have to pay if I was on Medicare. So that's what happens when you continue to work beyond. Is there any chance of these folks reaching an agreement? In other words, are you denying that your client agreed to this and had second thoughts about the maintenance?
No, I'm not, Your Honor.
Yeah. Well, I would suggest to her that she might not get anything. If his law is correct, I'd suggest before they leave, you take her back there and talk to her and see if she makes some reasonable counteroffer over a 5-year period, and I'll let you bring back up and tell me about that, okay? You don't have to accept it. You might think you got law strong enough or not, but a good settlement is a good thing, okay? Thank y'all very much. I'll see you in a few minutes. Okay, Midland Credit Management versus Upchurch. Motion for.
Good afternoon. William Rich on behalf of the plaintiff. It's a motion for summary judgment based on the defendant's failure to respond to the request for admissions, which were sent to him back in 2022. When no response was forthcoming, we did send counsel a letter indicating we'd not received responses to motions to our discovery.
Okay, who's the attorney on the other side?
Mr. Cross.
Yeah. Okay. Mr. Lavett, would you and Ms. Guilfoyle just turn your cameras off just for a second so I can get a concise record here? All right.
Is this on Arnie Upchurch, or who's it on? Or no,
It's on
Sister.
RB Upchurch.
That's right, it's on Arnie.
Arnie Upchurch. And what do you, and Mr. Cross has failed to respond to requests for admissions and interrogatories, is that correct?
That's correct, Your Honor. Also, we've received no response to the motion for summary judgment, no counter affidavit.
We'd offer no defense, Your Honor.
He has no objection to the entry of your motion for summary judgment. Did you submit an order?
We did, Judge. There should be in the file.
Thank you for your appearance. Sherry Butler versus Charles Wayne McIver.
Good afternoon, Your Honor. Mike Guilfoyle here for Ms. Butler.
Yes.
Mr.
Lavett, is that you?
Ted Lavett. That'd be me, Judge. That'd be me.
You want to mediate this thing?
Can you hear me, Judge? We could go to mediation, but Judge, we're trying to evaluate the wife's business. And we have not been able to get the information that we need. So, I mean, we can go to mediation, but I think we have to do this first.
Do you not have a disclosure statement listing the assets, or is there going to be the necessity to get a business evaluator to evaluate the value of the business?
That's correct. That's correct, Judge Williams.
Have you hired such an expert yet?
We're in that process of finding one, Judge. They're pretty busy. We're going as far as Louisville to find one, and she's agreed to help us. She's agreed to help us. She said in December, and so we're on our way to having somebody employed to do the job.
Judge, may I respond?
Sure.
We provided complete discovery. We also had an informal several-hour meeting between both attorneys and both clients. And subsequently, Mr. Lavett said we may need to do evaluations on both of their properties. If there's going to be an evaluation on her business, then we also need an evaluation on his. He has an extensive list of oil drilling equipment. I mean, just extensive. We've made a proffer of settlement. I believe mediation would be fruitful if he wants to have this court appoint someone to do a business evaluation on her real estate business as well as his business and all of the equipment that he has. We have no objection to that.
Well, Mr. Lavett, let me say something. I know who these parties are. I don't know either one of them well, but if you have survived in the oil and gas business with equipment and stuff like that, you have to be pretty savvy about what things are worth. in the real estate business, you have to be pretty savvy about what things are worth. I think both of them, if you took them and honestly had them write down amount of money that they would take to walk off and had a good mediator between them, this case could be settled. We're not dealing with people that are not sophisticated here.
Well, but Judge,
Now,
we'll-
so who would you suggest as a mediator? If the camera angle that you use now doesn't scare them off, we could get a mediator. I don't know.
James Mattingly would be a good mediator.
Judge, I don't know Mr. Mattingly. I know there are plenty of mediators in Bowling Green and in Louisville, but I'm not aware of Mr. Mattingly or where he's from, but I have no objection.
Mr. Mattingly is a well-known attorney and a respected member of the bar. I think that he would be as good as anyone. If y'all submit me an order that you will have a mediation as to the value, and then anybody is required, Mr. Lavitt, to bring any documents or any disclosure or any other things that you might have that would affect both sides, it would affect the value, and hopefully get together sooner rather than later and reach an agreement about these things. I will tell you from experience, both personal and professional, that these evaluations of businesses can be expensive, and then the testimony of them, if you get another one, and then you really don't have anything but two opinions that you ask some judge to decide, and that can be dangerous also. Okay, will y'all submit me an order with Mr. Mattingly, and if you, Mr. Lavitt, why don't you, can you prepare the order since you know the address of Mr. Mattingly, or can you get Ms. Guilfoyle the address and she can prepare it now? You have his name and address?
I'll get Ms. Guilfoyle the address and she can prepare the order.
Okay.
That works.
Okay, well, thank y'all for your patience.
Thank you.
Great. Thank you, Judge.
Happy holidays.
Thank you, Mr. Lavitt. Merry Christmas, everybody.
Thank you, ma'am.
Vanderbilt Mortgage and Finance versus Chad Horner. Vanderbilt Mortgage, and it says, yes, that is the motion to vacate because they reached a settlement. We will enter that order because it was made by the plaintiff. Make sure we set that aside. Medical Center at Clinton County versus Journey Poor and others. Good to see y'all again.
Good to see you, Your Honor. We tried to mediate, we're not successful. Judge, I had, at the court's request, had tendered an order following the last hearing. Here's what we request the court to do. Set aside the default judgment against Journey Pure LLC. Set aside the default judgment against Journey Pure Holdings, Inc. Grant or overrule the motion to set aside the default judgment against Journey Pure Bowling Green LLC and In-Re Recovery JP LLC.
And
you want time to digest that a little, or you already?
Yeah, no, we agree, Judge, that the answer is proper. And for Journey Pure Holdings, Inc. and Journey Pure LLC, because an answer was filed and they hadn't even served yet, so the answer wasn't late.
I remember last time.
So I agree with Mr. English on that.
Okay.
The rest of them, we would request the court grant our motion to reconsider. We had filed an answer, but it had not been done with a motion to file a late answer. So the court.
I don't think that you filed an answer. I don't think that's right.
Well, there's an order actually there was an order entered striking our answer for all four.
I mean, a timely answer.
Right, no,
I mean,
that answer was late, Judge.
You know, anytime anybody files a motion for default judgment, anybody comes back in can file a motion, usually for leave to file an answer, or they can just file an answer. And I think in your situation, they didn't move for leave to file an answer. They just went ahead and filed a late answer. Is that right?
That is correct, Judge.
Yeah.
And now
so I gave a default judgment, And I think there was a similar lawsuit going on in Bowling Green. They claimed that they'd gotten mixed up with this lawsuit here. Isn't that right?
Yes, sir.
With the exception, Judge, actually, you did not enter the default judgment. They had submitted one and it had blanks, and you.
And I told him to get, I remember telling him to get some damages and fill it in. I wouldn't know.
We did fill it in. That order was signed. A default judgment was granted. We are saying that we're agreeing that you should set aside against Journey Pure LLC
The
and Journey
ones that
Pure.
had not been served.
Correct.
Yeah. I'll
And
do
then,
that.
and then the other entities were served
Yeah.
and were.
Have I previously signed an order with the amounts in it
Yes,
against
sir.
those in default?
I think that was after they had filed those answers. But nevertheless, Judge, we have filed a motion requesting that the court reconsider that order, striking that answer.
Why is that?
Well, there's three factors under the rules. Actually, the courts and the law says that this is to be liberally applied, and I think this court.
I'm known to be liberal.
I think this court has proven to do that. Three factors. There has to be a valid excuse, and that's been briefed and shown. That the confusion here, actually, I understand it, in that we have Journey Pure of Bowling Green, and we have another lawsuit of Journey Pure of Bowling Green in Bowling Green Court. Our clients, of no fault of their own, our clients get served. They send it to the attorney in Philadelphia, who then is the one who made the mistake, who says, okay, April's taking care of that because we have Journey Pure Bowling Green
I don't remember that part.
and a lawsuit of it. So our clients were diligent in what they did. And in that regard, the confusion of there's a lawsuit.
It appears that any action that they've had would be against their counsel then, if they were diligent, you know.
Well, in that regard, Judge, still, that's a valid excuse, and it's not caused unreasonable delay. And in the fact that
What's your next argument?
Number two is a meritorious defense. And in the answer, there was defenses pled. We have briefed mitigation. There's certainly, they got a default judgment for $400 and something thousand for every month of the lease. The law is very clear that when this happens, they have a duty to mitigate their damages, and to say that
I'm sure that they'd like to lease that property in Albany, Kentucky for someone.
We lease it to Lance right this moment.
Well,
It's not like it's in Bowling Green.
that's still a meritorious defense. What efforts have they done to do that? What is the market? All of those things, our clients deserve to be able to litigate, at least
What's your next argument?
litigate those issues. And lastly, absence of prejudice to the defendant. And we're not talking about a 3-month delay or a 6 months delay, or that they came in a year after they started collection proceedings. Actually, I believe, and I may stand corrected, our answer that was filed late crossed paths with this judgment that was entered. I don't think that.
Oh, the last judgment that was entered with the numbers in it?
Yes, the last judgment that was entered with the numbers in it. And I may be mistaken.
Of course, they were entitled to the judgment that they presented without the numbers, and I didn't want to enter a blank judgment. So I'm sure by then you found out that the judgment was done, and so what we're doing is they reduced it to number, and I don't know.
Nevertheless, what is their prejudice in this? What is the time delay? There's been no evidence lost. There's been no, they've
Well,
not been prejudiced.
the prejudice of them would be incurring thousands of dollars of legal fees and trying to prosecute their case because your client's attorney didn't answer it. Does that count as prejudice?
I don't think so, Judge. I think it looks at how is their defense in the case, or how are their ability to prosecute their case, how has that been affected by this? Actually,
What do you say about that?
Judge, my client has got a building out here that these people signed a lease on, that had a provision in it that if they didn't pay the lease as it was due, then the whole thing became due and payable. They signed it. These are sophisticated This is
Acceleration clause.
acceleration clause.
Except the law says they still have a duty, even in the presence of an acceleration clause, to mitigate their damage.
We are still trying to lease it and haven't leased it to anybody. We haven't been paid since
Well,
October
it would appear
twenty-second.
to me, if they're still trying to lease it, that, if they ever do get leased, that your client's obligation, you're saying, will be affected because they would know the money that had been accelerated. Is that what you're saying?
Correct.
What do you have to say about that?
They signed the lease.
No, what do you have to say about it?
If
you
we-
if you lease it
If we lease
next
it
month?
and we start collecting on rent before within the time of the acceleration clause, I agree that once my client has determined the amount of damages, if they paid us the full amount of the default judgment, that they might be a basis to come back and ask for a refund. But that's gotta happen first.
I don't know about the refund thing, Judge. I think once though, I think there'll be a different argument if the default is allowed to stand and we come into court and say, hey, you all owe some money back. I suspect the argument will be different in that regard. And in essence, we need the opportunity.
Things evolve.
Right. I think it would be a travesty for this to get entered, them to collect their $437,000 and then rent it to somebody
But
next
is it
month.
Travis, if y'all will walk off and move those things out in the middle of the night and leave that building empty and not pay your rent?
Well, there's extenuating. I mean, that's not necessarily what happened, Judge. Our clients purchased.
The last time, you were new in the case last time.
Our clients purchased this company and did sign some acknowledgements of this lease, but the actual two gentlemen that we're dealing with now weren't the ones that signed this lease. They did.
They're the ones that set up the deal and then sold it to someone as investment bankers or something.
And you know what, Judge? They acknowledge on the agreements that these were still their responsibility.
Then the litigation that
Well, let me ask you to solve this problem. Okay. Let's say that you've got someone who, let's say I say this lease is valid and there's no clause in it that lets it be broken. Okay, now your clients have acknowledged they knew the existence of the lease. Do you think that you're ever entitled to collect under an acceleration clause lease payments that are due if the contract is breached? Generally, I'm not talking about this case. I'm asking you to go back.
Or say first, all the parties should have the opportunity to litigate that issue and
Well,
let the
I'm not
court make
asking
that
you that
decision.
part of it. You know, I understand that's your position. What I'm asking you, if a lease is breached without good cause, I'm not saying that's the case.
And we have pled due cause.
Well, I don't know, there's no reason you give me, to give you a hypothetical question because you refuse to deviate from the facts of the case. And that's your prerogative.
I will answer your hypothetical.
No, it's okay. It's your prerogative. You don't have to ask the hypothetical question. Okay, is there anything else either one have you say? No. Okay. I was trying to give you an out on this thing, but you're not helping me any.
I will listen to it, Judge.
Okay, what I'm asking you is, we've got a lease with an acceleration clause here, okay? And let's say that I default you out, that you did not present a defense to whether or not the lease had been breached, not because I defaulted you out. Okay. Then what sort of provision would there be to allow you to continue where the plaintiff have to meet its obligation to mitigate their damages by trying to lease the thing? Is there any provision for that? How would you know if the case is over, is what I'm saying. And you have no way to demand discovery from them or an ongoing report to say, yeah, we tried to lease it to Dollar General store, but they have 4 locations.
Correct. I think that is what's lost in this by there being a default as opposed to allowing that to be explored and litigated.
Could I just respond? Because here's what we have here, Judge. We have two sophisticated, both lawyered up entities that negotiate a lease that includes a provision that has an acceleration clause.
Who sell that to another sophisticated group
We're all lawyered up and everybody looks at it and does it. And then all of a sudden, everybody's coming in and saying, oh, well, this is, even though we've been all lawyered up, we wish we hadn't signed this agreement. But it's a situation, it's clear. No one's taking issue with the fact that acceleration clause is in there. No one's taken issue to the fact that they've got sophisticated lawyers, Philadelphia lawyers even less, who look through this. And I'm starting to sound like Mr. Cross, and I'm going to be quiet.
Except what Mr. English is doing there is arguing a motion for summary judgment, as opposed to arguing whether we should get to file a late answer and litigate those issues. And then if that is the case, then the court can rule appropriately. But his argument's a summary judgment argument right there, not.
I don't know who's got the assets, which one of these LLCs or, I don't know.
No, nor do I.
I don't know. If he's got a judgment against the people who got the assets, he'll want to try to execute on those as soon as he can. If they don't have any assets, then your other clients will have an opportunity to present these defenses. And, I would say that you probably come in and try to set aside the default if the defenses prove that, which would be hard to do. I really don't know what to do in this case, to tell you the truth. I know that I've signed that. I think that the default judgment that I signed was legitimate when it was presented to me. The only thing I wish is that it had numbers in it when it was presented to me. We didn't have to delay. But I don't think that you denying a default judgment because it didn't have the numbers in should give you your clients who were not diligent in filing, their attorneys who filing an answer. I don't think they should benefit from the fact that I try to protect them against a larger amount being entered than could be justified. So I don't know.
I think, Judge,
what are your clients willing to pay to walk off from this? Do you have any settlement authority?
I do not, Judge. We made cash offers at mediation and offers to make.
Y'all didn't make any progress at mediation?
We made some progress.
We made progress.
We didn't get close enough to pay. See, it's not just the lease. We made improvements.
Yeah, modifications. You're talking
modifications. We provided meals and all that, and all these other things.
Did you have patients in out there, actually? Were there patients in?
Well, we didn't have patients in their part, but yes, we did have patients.
You're talking about what you incurred because of this, whose meals you provide their employees?
Yes, well, their patients and other people.
So there were patients in there. And you were under contract to provide certain auxiliary services.
Exactly.
To their patients.
Judge, the one thing I would say is where you said it's a close call, you don't know what to do. I think the law tells you in those situations, the court is to favor the liberal application of it and allow the answer to be filed and allow the case to be litigated. I think I think in those close situations, that's what the law says it prefers the court to do.
Well, I don't think it's a close situation as to whether or not your clients, some of those clients were in default. That's not what I do. The thing that bothers me is you got 1 foot in and 1 foot out, and some people in and some people out. But I would suggest that you go back to the table again and get your clients to understand the potential exposure that they have and reach a settlement on this thing. This is not. I've lived in Cumberland County, Kentucky, for most of my life, except the time I spent in Frankfurt when I was at the Kentucky University Law. And I know Clinton County well. And I looked at this lease and I know the shape of rural hospitals and who are wanting to move into hospitals and things. The only possible tenant for anything like that I could see would be an addiction recovery sort of group, ARC or somebody like that who saw some premises that would want to come in and lease. I would suggest that your people get out and try to help find somebody else to lease that property at that amount or more, but I can't force you to do that. Okay. Is there anything else? I'm not going to. I'm going to give y'all until the 11th, and on the 11th, if y'all haven't made any progress on this thing, I'll have my staff lawyer and I sit down together and find out what she has determined, and I'll add something to that, and we'll sign an order. But I suggest that this is a case that needs to be settled. You don't need to. where are you gonna, getting a jury is gonna be hard in something like this. It's gonna be hard. Whether it's in this county or any surrounding county, it's gonna be tough. But your clients need to realize, it kind of reminded me of one of my clients, Noel Singer, one time. I'm gonna tell you an anecdote. He was the founder of God's Land, the big oil and gas thing down here in New York. And one of the investors had given him a check for $10,000 on the People's Bank of Monroe County. It's gone now. And Noel had an account over there. So it was more than 10,000. It was like 50,000 or something like that. So Noel wanted to go over there and deposit the check. And I said, this check is from an oil speculator. What you need to do is go over there and present the check for payment. Don't deposit it. Present the check for payment. So he went over there and presented the check for payment. They gave him a few minutes, checked with the corresponding banks, everything, and paid him the money. He deposited a portion of money in his account thereafter. The check ended up being bad. And the president of the bank wrote him a letter and said, we have credited, we're taking that money out of your account. We did not intend to lose any money on this transaction. So I called the president of the bank and told him to put it back in, the money, because it had been presented for payment, and to submit his letter to Reader's Digest to say that they did not intend to lose any money. And I'm sure these purchasers did not include to lose any money on this transaction in this business here. But you make bad deals sometimes, and sometimes you lose the money. Now, you're saying that all that ought to be fettered out in court. We ought to do all that and everything. From what I see now, and it might be better for summary judgment, I don't see much defense. And I've read the contract and the acceleration, and I don't see much way out for your people. It might be cheaper to get out now than it would be later. So that's not saying that I won't give them a chance, but I think they're treading water. They got a bad deal and they're going to get out of it the best way they can. If y'all want to talk to me, I'd appreciate it. Thank you for being tolerant. Merry Christmas.
Merry Christmas.
Okay. Tracy Huff versus Bridgeman.
Good afternoon, Your Honor. This is Jason Swinney. I'm here for Lauren Marley.
What do we have here? Motion to withdraw?
Yes, sir.
And who do you represent?
I'm Don Piscano, represent the defendant, Ed Brumley.
Okay. Mr. Marley, do you have any objection to Mr. Piscano withdrawing?
No. Plaintiff's attorney is withdrawing.
No.
Okay.
Yes.
Mr. Marley, you're wanting out.
I'm Mr. Swinney. Lauren Marley is the primary attorney now, but she is sick today, so she asked me to step in and cover it.
You're standing in for an attorney that wants to withdraw.
That is correct.
Why does he withdraw?
And I'm sorry, Your Honor, what did you say just now?
Did you? It's she, Lauren Marley. She wants out. Has she not been paid? What's the deal?
Lauren wants to withdraw, but after the plaintiff fired her without cause and then shortly thereafter accepted the same offer that she had before.
You're representing Morgan and Morgan.
Correct.
Yeah. It didn't have that on there. When I read the motion, I got a little mixed up because it was Morgan and Morgan. So
she's filing a motion to withdraw.
You represent the lady that took the money?
No. I represent the defendant, Ed Brumley.
Yeah.
And the only issue, Your Honor, is certainly Morgan and Morgan can withdraw. The issue is they're trying to make a claim for 40% of one of the previous offers. That's inappropriate. It's really quantum merit, and probably more significant, it's probably premature for the court to determine the fee, because she may get another attorney and then he may have some right to an attorney fee. Yes, sir. And that's all down the road.
Yeah, well, I think that's.
She's already settled this, Your Honor. She's not hiring another attorney after she settled the case, though.
Did she settle the case?
No.
He says the case hadn't been settled.
Okay, my understanding is she's attempted to accept this last offer that's on the table, the same one that's there.
Attempted to accept is not, what would you suggest to protect the position of Morgan and Morgan if they do have one, Mr. Piscano?
Well, Your Honor, I think they're protected because they filed an attorney lien.
Yeah.
So that's in the record.
Yeah.
The court can make a determination later on what they're entitled to. But that's down the road. If she gets another attorney, then they can address that issue with the court. If I have to sell it with this lady, I'll have to come back and present what I think is a fair fee for them, which is essentially quantum merit.
Yeah.
Your Honor, if she's not hiring another attorney, then I don't understand how quantum merit would come into this equation.
Has she hired another attorney?
No, not that I know of.
Is she dealing with you directly or what?
No, she's kind of dealing through Mr. Brumley. Mr. Brumley is, they have some relationship, not exactly sure. She has called me to see what's going on. Several times I told her, I can't talk to you until your attorneys have withdrawn.
Your Honor, I believe that the intention is once the attorneys are withdrawn, she will accept the settlement offer.
Well, there's an attorney's lien on it.
Right.
And they're not going to pay out and sign anything till the attorney's lien.
Right, but to the extent that we're talking about the quantum merit situation here, we want to make sure that's understood. If there's not another attorney involved, the quantum merit doesn't come into play. Otherwise, plaintiff's just going to fire their attorney and accept whatever the last settlement offer was when they're ready to settle the case and not pay an attorney fee. I just want to make sure we're not overcomplicating.
I understand. Well,
if her intention is to go ahead and accept the offer after we're withdrawing.
Let me see if we can get an order that would accomplish this. In other words, get an order to say that if settlement is reached, that the party's defendant will recognize the attorney's lien if there's not another attorney involved. And if there is another attorney involved, then they can present the conflicting quantum merit arguments to the court. We'll reserve a judgment on that. That would protect Morgan and Morgan and let the defendant move on with trying to settle the case.
Right. And Your Honor, we do have an issue with, they're claiming a $50,000 fee, and we think it's pretty clearly quantum merit. So we can address that with the court later on.
I believe it's a $60,000 fee.
Do what?
I believe it's a $60,000 fee.
60,000. Yeah, 60,000. Well, I know. Do you think, you got a 40% contingent?
Yes, Your Honor.
40%. Well, it sounds like she needs to lawyer up, so you're wanting to, Morgan and Morgan is wanting to withdraw.
Yes.
Correct?
Yes.
But you want to protect your attorney's leave to be decided later.
Well, we'd love for it to be decided now, Your Honor, but yes.
It ain't going to be decided now, So you're going to withdraw. So submit your order, allow you to withdraw, and tell that the court will consider at a later date as appropriate any issues as to the attorney's fee. Okay. And that'll be all I'm going to do today. And then I will put the defense on notice, Mr. Piscano, if you advance to settle this case without her obtaining an additional attorney who might have a quorum merit case, or if she wants to appear with a quorum merit case, she needs to appear in court with her own attorney to make that case. It's not your obligation to do that, obviously, correct?
Right. That's right.
Yeah. Okay, is that all right with everybody? You're gonna draft the order and send it down to me, Mr. Sweeney?
Yes, we can draft an order to that effect.
You want to circulate it to opposing counsel?
Certainly.
Now, were you any relationship to Professor Piscano?
I was. That was my dad.
Well, I had him in class. He was wonderful. He was very entertaining.
Thank you.
And was a great man. But the only problem that I would complain if he were still with us today, and I assume he's not, is he had an 8 o'clock class and it was pretty tough. I'm sure you have a lot of people that acknowledge.
We do. That's nice of you to say.
Yeah, well, it's good to see me.
You and I had a couple of cases a long time ago too.
Yeah, well, you must have beat me and I've forgotten. Okay, well, all
Got
of you have-
memory on the right ones, Judge.
Thank you very much, yeah. Okay, Credit Acceptance Corporation versus Johnny Jones. Credit Acceptance Corporation versus Johnny Jones.
It's not long. Or just not, that's what matters.
Motion, okay, didn't send the file over. Okay, now we got anything that we're trying to call back here?
Your Honor, we've got the, call back the, Gibson versus Gibson. Yeah, I know there's been a lot of confusion, various things regarding the Mitchell versus Warner. I know the Mitchells are here.
Well, let's just do one case at a time.
Yes.
Or we could just throw them all together. It's global.
And
No, you're gonna get a trial date here. I'm sorry, I didn't see you over there.
Oh, that's all right.
I didn't have my glasses on.
Oh,
I would have called you
I
out.
just thought you mad.
Well, if I was, no, I'm sorry. I
No,
didn't,
it's
I
all
didn't
right.
see over there. My problem is, I need to go to one of these, like these headlight places that get this, I mean, I can't get my, and I don't need to read with them. And I can't get them cleaned up to see at a distance. Okay, what have you got here?
Mr. Cross, we said that Cody Hughes case is one, he's saying he can't do it.
got thousands of things on, I don't, Eric, I don't know what that's here, but anyway. we
Well,
can
you
get
should
it.
have been here. We just hear rock once a month.
Well, if I'd been here, I hope we would have got it settled. And he didn't back out, but apparently there's some confusion, so.
And no confusion. She said that it didn't work. That
Well,
fell apart.
she shouldn't have said that. I'll say that.
So you're saying when you send somebody up here, we can't depend upon what they say?
I'm saying I have
Okay,
better, I have
let's-
better client control.
Yeah,
So,
okay, well, we're gonna try this case and we'll see what. I have no problem if somebody has a legitimate conflict to continue. Now, this was in January. 8th and 9th. Yeah. And when do we have here, Mr. Stockton?
Well, we've got Mr. Foster and.
What about the 29th and 30th of January?
got tonnage of stuff that day, Your Honor. I'm sorry, on the 29th.
How about the 30th and 31st?
I've got two disability hearings on the 31st, Your Honor. You know, it's just hard to move.
Well, why don't you come up with some dates?
Okay. What about the, it's like the 16th and 17th.
I'm not available on the 16th.
Okay, 15th 's holiday.
That's the reason I'm not available the 16th.
Let's go off the record for a second. I mean.
What about the 5th and 6th of February?
Got two social security hearings that day. I've got a bunch stacked up. They don't do anything in December. They're on the 5th.
What about the 6th and 7th?
Yeah, we had a trial schedule on the 5th and 6th. It's been said, I said the trial, so we have the 5th, 6th and 7th.
I've got another one set on the 7th. I mean, I've just got them stacked in there.
There was a 7th of February, but it's, I got an email last night, but it's got 7th on there.
Well, I could do the 20th, 21st, up that during the 21st. I don't care whether to do that.
Well, keep it this one.
That's your prosecution.
No, but you're in January or February.
And everywhere.
Yeah, that's, I'm not thinking,
You can't do,
all of us are.
you said you can't do
The only good conflicts I've got is what you want, that's the 19th through the 21st of February and 16th of January, that's only 4 days, those 2 months.
well, the 19th is it's President's Day. But I mean, I can do it that day. The 19th and the 20th actually work really good.
That's what I'm saying,
It's
Dave.
just crossing.
That's what I'm saying, I've got 4 days out of 2 months, I'm not available, 3 of them. I can't go around this building yet. I guess we're just gonna have to leave it on the same day.
How about the,
Y'all can't come to agreement.
we're trying, we're getting over toward March, you know what that is. I mean, it's just,
Well, your client will either been found not guilty 2 months earlier or be in the penitentiary, whether in March, I don't know.
what about March 4th and 5th? I don't have the same on those 2 days.
I'm not. We got another case that's depending on this guy.
Boston,
Yeah,
he said for the
7th of what?
March. You said
That's
that's for free trial.
free trial, so we need to have it before then.
Correct.
4th and 5th.
And then the judge. I'm available.
Ayes. March 4th and 5th, I'm sure there's something I really need to do on those days that I don't have on my calendar, but I'll give it and I'm easy. Apologize to you, Mr. Stockton.
Oh, that's all
I
right.
didn't see you over there.
I got to visit with Mr. Peace Conner. We were classmates last night.
Yeah, I had his father in class.
I did 2 days for college.
Yeah.
He was there.
8 o'clock in the morning.
What was his first name? I think it was, I had him 8 in the morning too.
I didn't see him as frequently as some people.
I'm sure I was there doing you.
Yeah.
I'll see you.
Thank you, Matt.
I've been Benjamin Piscon, maybe something like that.
He was a big,
Yeah, he was, yeah. Okay, is there anything else? What other cases?
Your Honor, we've had the Mitchell versus Warner, formerly known as Mitchell, and that's the case, Your Honor, that back last several, I think in August or September,
Is it on the docket today?
Yes.
We sent you back there and what?
That's the one that
Yeah, we'll say it again.
Well, Your Honor, if I may address the court, because my client is here and his family, and I feel like
I'm not going to hear the case.
I know, I understand if you're not going to hear the case, that's fine, but I'm beseeching the court to set a hearing date. I want,
Okay, well, I'll be in my office tomorrow. What is tomorrow? Darn, I'm gonna miss it again this year. I'll be in my office on Wednesday, correct? Be in my office on
Wednesday morning.
10 o'clock or so.
I'll be over
Get
there.
opposing counsel on the line and we'll get our calendars out and
Thank
set a date. Okay, I guarantee you we'll set a date.
Well, that's what we've tried to do, and
No,
Ms.
we're gonna
Huntley's
do it
not
on Wednesday,
cooperating.
so you accomplish your goal here today. Their presence won't be necessary, but we will set a date and their trip will not have been in vain.
Thank you, Your Honor.
Okay, thank you very much. Now, is there any other case?
You want to revisit this Gibson versus Gibson?
Let's do Baker versus Baker, if you don't care any quicker.
Yeah, go ahead.
Your Honor, we still are of the position that the settlement agreement as agreed upon, as set forth in the correspondence immediately following the conference is
And
the
so
deal
they couldn't
structure.
change their mind after that.
Just the terms that have been set forth are
I'll look at the law you have on it. I'll be glad to look at the law. I just can't believe that. I can't believe I never would have relied upon any settlement agreement that I had until I had it inked. I wouldn't have agreed to that, even if the attorney said, okay, and unless it was on the record. I have frequently had people come and get sworn on the record just to avoid that sort of situation where people get cold feet or get separate legal advice or get somebody kibitzing, that's involved in things. So, if y'all don't want to meet for reach an agreement, that'd be fine. I can handle it. Besides that, it's the $500 a month for how many years is the issue?
5 years, Judge.
Yeah. I'll take a look at it. So.
But again, Judge,
Did you offer them anything, or are you just solid on your agreement?
the agreement is not only good, but it was ironed out and it was meant for a
I'm just
reason.
asking you a simple question.
Nothing else additionally
Sometimes
was
you ask
offered.
people what time it is and they tell you how to make a clock. So I'm just asking you, did you offer them anything? You don't have to tell me what you did, so it won't prejudice me. I don't want to know, but you offered them something, or you just standing on the law, and you might be right on the law. I don't know. I hadn't looked at it in detail, quite frankly.
It's not.
Okay, you got anything else you want to say? Okay. Okay, well, thank y'all for being here, and I'll take a look at it and get y'all an opinion now, okay? Thank you very much. Hey, is there any other case out there?
Gibson versus Gibson.
Hey, can I have Trish come in?
I'm sorry, Your Honor.
Yeah, that's okay. Now, where are we here?
Your Honor, this was the,
I know what it was about.
I want to offer some testimony from my client's mother regarding the history of this case and Mr. Gibson's involvement with these girls over the years, because there's been some allegation that it's been very sporadic.
Here's the deal about it.
Yes.
I'm not going to take any testimony from anybody, no matter how well intended it is, if he's not here.
Okay.
I want to be able for them to have the opportunity to confront and cross-examine him about something. But this case is not going to be settled today. The division is too deep. The intent of one of the parties to do it, to terminate parental rights and adopt is probably can't be changed. And the father's involvement down through the years is going to be litigated in that. So there's no reason for me to litigate it in this. What I want to know is if there is an agreed upon place that your client feels safe to let this father visit the children with an order that he shall not discuss anything involving the disagreement that the mother and father have, and someone present to listen to make sure that doesn't happen. My main concern is the best interest in the children and they not be damaged any more than necessary. Now, do y'all have anybody, if you want to step away and see if there's anybody for, like a 3-hour visitation on Christmas Eve or something like that? And then maybe we can get into this more robustly next month before the rule day. Okay. Y'all have anybody in mind?
Oh, but I don't know, see why she would let them come to my house. Judge,
What did I say I was going to do?
I mean, given the circumstance that Mr. Gibson has not had any contact with these children for over 6 months, she would not be comfortable.
Well, it's going to happen.
She would not be.
He's going to tell me a person or a place that just a couple, 3 hours.
No. No. She said she would be agreeable if he wanted to come to her house with her husband supervising.
No, that's not.
Or at the cabinet because of issues.
The cabinets, it's Christmas.
I
It's
understand.
Christmas.
Judge.
Now, wait just a second. You go on out of the courtroom.
I'm
Just
sorry.
leave.
Thank you. That's better.
Oh, my God, please.
Okay, now, here's the deal. There's bound to be an aunt or an uncle or a church friend on your side of the family, it wouldn't mind, it doesn't have to be on her, his side of the family. A mutual friend that both of you still get along with, although you hate each other. There's bound to be someone that would allow him to exercise a short visitation before Christmas. Now, you might terminate his rights. I'm not prejudiced about that, but at some juncture, these children are going to need to know, or at least feel that at some juncture their dad tried to do something to keep the rights getting terminated, even if they need to be terminated, so they don't feel like he abandoned them. You know, there are all kinds of issues. Maybe you think he already has abandoned them. I'm not getting into that right now. I'm just asking you to come up with somebody to allow this father to have a short Christmas visitation with his daughters. Now, y'all want to go back, think about it for a second.
But we don't know if she would agree. I could call her. Judge, the only issue is, I mean, the people that she would suggest, we don't know that they would be willing to agree to do
Okay,
this.
well, I tell you what, that's a reasonable response. And I want you to come up with someone in the next 48 hours to allow him to usually have your Christmas on Christmas Day or Christmas Eve.
Well, we do Christmas Eve with my family that night.
Yeah.
And then with my husband usually that day.
Okay.
On Christmas Eve.
On Christmas Day. Okay, so what time on Christmas Eve do you usually have your thing?
Well,
Hey, would you prefer them to have like the afternoon of on Christmas Day?
yes,
Okay, well, that seems reasonable.
yes, Christmas
So
Day.
let's try to find a spot agreeable to everybody in the spirit of Christmas on Christmas afternoon to allow the little girls to go somewhere that they're comfortable, not somewhere new, somewhere they're comfortable, but maybe allow their dad to bring them some Christmas gifts and just have a social time with them on Christmas Day, Christmas afternoon, 2:00, something like that, after lunchtime or something. So y'all get back with me. And if not, I'll pick one of these deputies home. They'll be glad.
Larry would be great.
Larry would be glad.
I agree on Larry, that's fine.
Yes, absolutely. Gail
Larry
could
talked to
be.
him about it on Christmas afternoon, you know.
I think we might have put Mr. Craig on the spot, Judge.
He's
sorry,
been
Larry.
in worse situations than this. Maybe these little girls get to ride around. Yeah, they get to ride around on a motorcycle. You throw in there. Okay, in all seriousness, let's try to work something out on Christmas afternoon. And then you go ahead and file all these motions that you're gonna do, so we can throw all this thing together and hear all the stuff that we're gonna hear, okay? And I suggest you take the mother by deposition and file it.
Your Honor, could my kids speak at all? And then
And that's one of the issues is the oldest child was having some phone contact and Mr. Gibson, we alleged did something that has upset the child and that I think it may be more traumatic. Reintroduce this individual into the child's home until we take some
You're
testimony.
gonna see the child on Christmas afternoon, and we'll get into all this sort of stuff later. You'll be able to bring all the reasons up why this parental right should be terminated. You'll have a full hearing and the children will be interviewed and things. But there's bound to be somewhere where they're comfortable enough and feel safe enough to come and let their father visit them shortly. And he's to be counseled to have a status quo order that he shouldn't do anything and talk about their separation, not being around them or anything, none of that sort of stuff. Just Merry Christmas stuff, okay?
Look at the names and agree to it.
Okay, thank y'all very much. I hope it works out. Yeah.
Have they, no, do anything for me today?
No, not today, because I didn't have Dwayne here and I was waiting on that. He was supposed to get back in
Is there
contact.
anything else that we have?
I don't believe, I suppose we'd settle the court case, but we're not going to.
Okay, let's go.